unmute, sir. Unmute.
You're unmuted, so you can speak, sir.
Yeah. Erudite and esteemed resource person of the day, CA Pankaj, CS Panaraji, Secretary of SIRC, other members participating from the southern region. Very good evening to all of you. In the last two successive Sundays, SIRC didn't have conduct any program. We to give a break of a day to our members from the regular CP programs conducted all other days preceding these two Sundays. I'm sure you are all eagerly looking forward to hear once again from another learned personality from our profession on a subject that interests you on the first day of this week. SIRC aware of the preferences and expectations of our members who evince the interest to learn more and more on diverse different subjects. Today, a 3-hour CP program on drafting of succession planning, instruments, wills, and trust by CA Pankaj from Indore. Yes, you are all aware the horizon of professional services for our fraternity is expanding widely, and we are looked upon to offer our valued services in different areas like arbitration and various kind of consultancies. Here is one more professional opportunity available for us. Keeping this in our mind, SIRC selected to have a session on drafting of succession planning. On behalf of SIRC FIC, I express my sincere thanks to the resource person for being with us. We take a great pleasure to offer our warm and cordial welcome to him. Welcome you, sir. I also wish to record the excellent support being extended by my colleague in this regional council conducting the programs and other activities of SIRC. I'm greatly feeling privileged to extend my warm welcome to all the participants. Today, the topic for discussion, the drafting of succession planning, instruments, wills, and trust is an interesting topic. And in our professional practice, we do come across assignments of this nature. It is therefore imperative that we keep ourselves updated on various aspects and its importance. Succession planning is an integral part of every person, as he is expected to plan both at family level as well as for the business. And if involved in such endeavors, a will and trust together can avoid litigation amongst the legal heirs and provide smooth succession. It is therefore obvious that the real life situations, financial planning and succession planning go together to ensure that we move forward without stress and strain. The family trust today are gaining increasing relevance and acceptance as tools for the succession planning. It is not only help to maintain the legacy, divide of disputes, and serves the core objective of distributing wealth in the predetermined manner to a certain beneficiary or beneficiary to whoever to owner wishes. Today, discussion by our learned resource person CA Pankaj would therefore revolve around the highlight and features and connected with the drafting of deed pertaining to the succession planning and the safeguard attached to it. I am sure the rich experience and expertise of our resource person would throw more light for making this evening session very lively and entertaining to all our participants. I would conclude that there should be a proper and effective succession planning to give a comfortable stability to our wealth created and future wealth creation. Members, tomorrow we are having the program on common errors observed in the disclosure under accounting standards, the Companies Act 2013. The key provisions on accounts and audit handled by the CA MP Vijay Kumar sir and the Joman K. George. With this, I once again extend a very warm welcome to each one of you to this excellent program. Now I request the CA Panaraji sir, Secretary of SIRC, to introduce the speaker of this evening.
Good evening and thank you, Chairman. for setting the tone for the day's program. It is a 3 hours program, CP hour program, exclusively on drafting of wills, private trusts, and also succession planning. So here, most of the cases we would be good at income tax law, but we would not. We would be fearing the litigation under some other law. So all these things, all these aspects will be covered by the learned speaker for the day. Welcome again, CA Pankaj Shah sir. He is from Indore. He is a chartered accountant, company secretary, bachelor of law, and a bachelor in business administration. Insolvency professional, registered valuer, and diploma in information systems audit, and presently pursuing PhD in taxation. That 2 lines shows his veracity of the knowledge. And he was chairman of the Indore branch of CIRC of ICAI during 1920, very recently. So he is mainly practicing in the area of direct taxes, international taxation, corporate laws, and represents in litigations before ITIT and NCLT. He is a member of the advisory board of Indore University. He is also a national faculty on technical subjects and has delivered more than 300 lectures. He is also a prolific author, and his views are regularly published in daily newspapers and renowned academic journals. With this, I present before you the very illustrious and knowledgeable speaker, Pankaj Shah. Over to you, sir.
Thank you, Chairman of SIRC of ICAI, Mr. K. Jalapati, Secretary of SIRC of ICAI, Mr. Panna Raj, August members of the profession, seniors, friends. A very good evening to one and all. Today, it's a great privilege of mine to speak before the members of the Southern India Regional Council. And interestingly and fortunately, it is my debut lecture on this topic at SIRC. I had been privileged and fortunate enough to speak at NIRC, EIRC, WIRC, and my own CIRC. And now I am able to speak before the Southern India Regional Council, which is a great privilege because till date I have learned from the learned members of SIRC, and today is my first chance to speak before the members from whom I have learned. I have been a great admirer of Mr. MP Vijay Kumar and all other great members of SIRC. Even Mr. R. Bhupati was their past president. So great luminaries have been there from SIRC, and today I am before you all. So the topic which is given to me is basically estate and succession planning. This topic has a great importance in our profession. Why? How? Recently, I believe a year or back, before this COVID had struck, I got a will of a retired IAS officer. He wanted me to vet the will, which was made by some financial service company, some banking financial company. And after looking at the will, and I just asked him a question, sir, how much did you pay for this will to that company, that financial services company? And I was surprised to know that he paid rupees 5 lakhs. 5 lakhs was paid just to make a will. So that brought an interesting question to me, that this is a great opportunity for us chartered accountants. Why? Because we chartered accountants are like a family member to our client. Any good thing, bad thing, anything personal, he shares with us, because we have a position of trust with all the clients. And now is the time we should encash on this trust and do some succession planning for our clients. Absolutely, we should remember that this succession planning or whatever advice we are giving, this is right now what we are doing is an investment. We are investing in knowledge, and definitely we need to reap benefits from this investment. It is said that the best investment is the investment in knowledge, which yields the highest returns. And today, that is why we are all here to discuss about the succession planning aspects. There are many aspects, as Mr. Panna Raj said, that we all are masters of income tax. But many a time situation comes that there are some preconceived notions of income tax which we apply elsewhere. These we will be demystifying these kind of concepts. Income tax says something. In income tax there is something which is said law, but the normal law, Hindu law, or the other laws which are applicable may not have the same principle. So we have to differentiate between those principles. We have to unlearn some aspects and relearn the nuances of this succession laws, which we are going to discuss today. So with these opening words, let me start my presentation. Sir, is it visible to you all? I believe
Yes,
it's visible to everybody.
visible. Yeah, visible.
Yeah. So my topic today would be succession planning, drafting of these instruments. But before we venture into succession planning, we should know the need of succession planning. See, in India, whenever we ask our client, sir, have you made your will? Our client used to look at it as a taboo. It is the Indian society's mentality that whenever we ask our client, yo, have you made your succession planning? Have you made your will? So the client used to think, why is he asking me? I'm not going to die tomorrow. But this COVID has taught us many things. The last 2 waves of this COVID pandemic has really taught us many things. And one very important thing is to plan the future. It is definitely much advisable because nobody wants that after his life, his near and dear ones should have to rush to the court and take succession certificate, or have to get engaged in the red tapeism of our system. So it is always advisable to have a proper succession planning synchronized with the nominations and other things, so that there is a smooth transition in things. I always recall and remember a great incident of Mahabharata. Yudhishthir was a great king of Indraprastha, and one beggar used to come to Yudhishthir. Yudhishthir said, "Arey Baba Kalana, you come tomorrow. Today I am not in a mood. You come tomorrow. Tomorrow I'll give you your desired donation." So that beggar was going. Bhim, who was the brother of Yudhishthir, he asked the beggar, "Why are you going back empty-handed?" Well, the king asked me, King Yudhishthir asked me, "Please come tomorrow. I'll not give you donation today." Okay, Bhim said, "You please wait." Bhim went up on the fort and started playing the trumpet. He was playing the trumpet loudly. So normally this used to happen when there was some kind of win, when the king used to win a war. So Yudhishthir came out, "Oh Bhim, which war have we won?" So Bhim said, "Oh brother, you have won over the death." Yudhishthir said, "How can I won over the death? I have not fought any war. What do you want to say?" Yudhishthir said, "Brother, nobody knows when he is going to die, and you are somebody who never says lie. So when you have asked this beggar to come tomorrow, that means you have a surety that you are not going to die till tomorrow, and therefore you have asked him to come tomorrow. So therefore you have won over the death." And Yudhishthir realized his mistake, and Yudhishthir asked that beggar, "Please take away right now, because nobody knows when death is going to approach." So this taboo in succession planning, now we need to advise our clients to please plan your succession properly. This kind of taboo cannot continue in future. So therefore, succession planning is something which is very important, and we need to do it right away. I have given almost 30-40 seminars on this very topic of succession planning. And when I was preparing for my first seminar, I went through all the subject, went through the nuances of what happens when we do not plan a succession, what is the law regarding interstate succession. And when I read it, you won't believe, I first wrote my own will at the age of 35, and then I started delivering the lecture. So first you need to implement what you need to preach. So now we are going to discuss and understand what are the implications and need of succession planning. So as discussed, we started with an example of Mahabharata. Friends, we all need to understand that proper planning, succession planning is very important. In abroad, we have recently seen the divorce of Bill and Melinda Gates. It is said many people are apprehending that this is a tax planning which they have done. So if they people can go to such an extent, why should we be aback in planning our succession by way of wills or other devices? So let's start with the need of succession planning. If you see, the first example of succession planning in our country, which shows the importance, is Mahabharata. The Hastinapur was the mightiest empire which has ever been, which had great warriors. The warriors which Hastinapur had, Bhishma, Pitama, Dronacharya, were so great, they were invincible. Nobody could win over them. But then there was no proper succession planning in Mahabharata. There was no division, no document, no planning in for Kauravas, Pandavas. So in absence of that succession planning, India's, or I would say the world's mightiest empire got destroyed. All the great warriors were gone, and then there was a reorganization. So therefore, one very important thing which we need to keep in our mind is succession planning is something very important. Another example is the Bhushan Group. Bhushan Group was a very growing group in late 80s, but then they had this succession issues, succession disputes, and this dispute wiped out almost $1 billion USD from their market value. So that was again a great disadvantage of not planning the succession properly. Another example, we see Modi Group. Modi Group, if you recall, GP Modi, Godfrey Phillips, they also had some succession issues. And since these succession issues could not be resolved initially, they also had to suffer. Then in the last 10 years, they have tried to recover and they made their planning proper, which has greatly added to their value. Another example of proper succession planning is the Dabur Group, Ranbaxy, Parvinder Singh. These both group planned their succession. They had a proper succession plan in place, which actually resulted in maintaining their group value. So if you talk about businesses, succession planning has to be done from a business level to even a single individual. Everybody needs to have a plan. So with this, we are starting with the benefits of succession planning. One first very important thing before planning a succession or anything is existence of a person in a guiding capacity. See, what happens when we do something or we plan something, a businessman is expected to make mistakes. So there should be a chartered accountant or person of eminence who has some experience, who has seen many cases, so that he can guide the people in proper capacity. This normally is done by way of board of directors. Earlier, there was a concept of having some independent directors who can properly plan things, who can explain things to you, who used to have a place of eminence in the board. But later on, with the Companies Act, criminalization and other penalties, even the income tax used to do searches on the premises of independent directors. Persons of eminence started refraining from becoming an independent director. So recently, many companies have made a plan of having an advisory board, which does not have any legal implications, but that is very important because the advisory board keeps on monitoring the businesses and gives you advices plan. One incident which I recall, when I was working in Mumbai, I got to attend a meeting. In the meeting, there was a very senior advocate counsel who used to attend the meeting. Lalit Modi, you all know, who is right now a fugitive, he was attending the meeting and he was explaining his business plans. Sir, I want to do this, I have this plan, then I would like to acquire this company and so and so. That learned gentleman listened to Mr. Modi for 20 minutes. And then he said, I still recall the words, they echo in my ears, Lalit, mind your speed, please go slow. If Mr. Modi would have listened to these advices, maybe the situation would have been different today. He may not have to go to London. He may not have to run off from India. So it is very important to have some people, some senior chartered accountant to monitor the succession planning. And it should be in his ages that this planning should be done. So here we have a rule. Normally, any businessman, we need to cross-question him, we need to interrogate him, and then we can devise a proper succession planning to him. Before coming to drafting of any plan, Firstly, you need to discuss with him. You need to give him, throw cross questions to him. Okay, you want to do that. Why do you want to do that? Can this be implemented in another way, a better way? So that is then somebody approached me, I want to make a private trust. I simply asked him, why do you want to make a private trust? He discussed his problems with me. I said, it is better for you to make a will and get it registered. This is a better way to go through it. So he was, that gentleman was convinced. So our role is not, the client comes with to us that I want to do this. Our role is not to just provide those services, but we need to provide him a better plan, or we need to understand the problem. We need to diagnose the real problem and give him a proper plan to implement. So with this guidance and basics of succession planning, now we'll discuss what are the different ways of succession planning. For example, the first one is interstate succession. Nothing doing, no succession plan made, no will written, and if a person dies interstate without making a will, what happens in those cases? Then second aspect is the testamentary will. When a person writes a will, then what laws are applicable? How will succession happen in those cases? What points we need to take care while writing a will? Third is succession through HUF, nomination, joint holdership. That is another very important thing. And if we combine will with all these instruments, HUF, nomination, others, we can get a very good solution. Another aspect is private trust. This is a special vehicle of succession planning in some special circumstances, which we will discuss in the later part of my presentation. So these are the different modes of succession. Then, now coming to the first thing, interstate succession. Interstate succession is when a person expires without making a will. What would happen in such scenario? Now, as you can see, succession law is in two cases. Firstly, when a person dies without making a will, so there is no will. Another is when there is a will. What laws are applicable in which scenario? Firstly, the laws are applicable according to the religion which the person follows. For example, if the person is a Hindu, Hindus include Jain, Sikh, they all are coming under Hindu category. So if a person is a Hindu and he has not made a will and he expires, then Hindu Succession Act shall be applicable. But if the person is a Muslim, then Shariat law will be applicable to him. Persons apart from Hindus and Muslims, for example, Christian, Parsi, Jews, there is no religious law and a kind of uniform code which is in the form of Indian Succession Act that will be applicable to all the others apart from Hindus and Muslims. So if a person dies without making a will, then according to Hindu Succession Act or Shariat law or Indian Succession Act, everything will happen. But on the other side, if there is a will, then for everybody apart from Muslims, Hindu, Christian, Parsi, Jew, Sikh and Jain, Indian Succession Act is the sole law which will be applicable. If you come to Muslims, they have a Shariat law. Now, these are the different kinds of law. Indian Succession Act is a kind of, what do you say, a uniform civil code. And I personally believe, this is my opinion, that a common law should be there. The more differences in law are there, the more problems it will create for every individual. So a single kind of law like Indian Succession Act, in case of testamentary will, it applies to everybody, Hindu, Christians, Parsi, Jew, Sikh, Jain, it is applicable. And for Muslims, it is Shariat law. Now, we'll focus more on Hindu Succession Act because it is the most complicated piece of legislation as far as interstate law is concerned. Now, as per Hindu Succession Act, there are 4 categories. First is a class 1 legal heir. What do you mean by class 1 legal heir? We'll deal it in detail. A class 1 legal heir is there. It is the nearest relative of a person who is expiring without, who is dying without making a will. So his property will be distributed to his class 1 legal heirs in equal ratio. Then assume there is no class 1 legal heir. Class 1 legal heir is a very wide definition with almost 16 persons who are defined in this class 1 legal heir. If there is no class 1 legal heir, then it will go to class 2 legal heir. If any one of the class 2 legal heir is alive, everything will go to him. Assume there is no class 2 legal heir also. It would happen in a case of a person who dies without making will, and he is not married, and he dies at a old age, say 70 years or 80 years. So he does not have any his mother, father, or any close relative there. So no class 1 legal heir, no class 2 legal heir. Then it will go to agnates. Agnate means persons from father's side, his legal heirs of his father, relatives from father's side. So that would be agnate. If he does not have anybody from father's side, then it will go to cognates, mother's side. So nobody from father, then go to mother, cognates. And a person who does not have any of these relatives, then if he has nobody to claim, everything will go to the government of India. Our constitution of India has a clause escheat. So according to that clause, if there is no one to claim, nobody can claim it, then everything will go to the government of India. So firstly class 1 legal heir, then class 2 legal heir, then agnate father's side, cognate mother's side, and if nobody of them is there, then it will go to the government of India. Now, who is class 1 legal heir? I'll explain in the simplest form, then we'll go to the complication. A person has expired, deceased. Now, he has left behind him his mother, his widow, his children. So everybody would get equal share. Now, please pay attention. Father of the deceased is not class 1 legal heir. His mother, his widow, his son, and daughter. So we have these 4 class 1 legal heirs, and they will get the equal share of the property of the deceased. So it will be divided in 4 equal shares. I hope I'm clear. Now, moving to another complicated example. Sorry, I have this because of this presentation. I have written all the relations in Hindi. I'll also translate in English also. When the person is expiring without making a will, now these are the 16 relations which are there. Mother of the deceased, his wife, his son, and his daughter. Assumingly, if these 4 relatives are there, it will go to them. Assumingly, his son is not there. His son dies before the gentleman. So in that case, his daughter-in-law will get the share. His grandson, he'll get the share. His granddaughter will also get the share. Take one step ahead. The person who is dying without making a will, his son has died before him. His grandson also dies before him. So the property will go to his daughter-in-law, his granddaughter-in-law. She'll get the share. His great-grandson and great-granddaughter from his son. But the person who dies without before his son dies, his granddaughter also dies before him. So his class 1 legal heir will be the daughter of his granddaughter. Son of his granddaughter is not considered as class 1 legal heir. Daughter of his granddaughter is a class 1 legal heir. So if we talk about his son, his grandson, granddaughter, great-grandson and great-granddaughter, but from daughter side, only great-granddaughter, not son of her granddaughter. Then another side, if you see from the daughter side, after 9 September 2005, daughters are having equal right as if son. So if you see, daughter has the right. If her daughter is not there, then the grandson from daughter side and granddaughter, they both will be having share. Assume they both are not there. So her grandson from her daughter, if he is not there, then the property will go to his daughter, not his son. So the property will go to his daughter, son of his daughter, but not son of his daughter's son. It will go to daughter of his daughter's daughter. And if you see from the daughter side, if it goes to his daughter, her daughter, and her children, it would include a boy and girl both. But if you see about the son of his daughter, it will not go to her son ahead. So these 16 permutation combinations who are class 1 legal heirs of a person, this is an important aspect we all need to know. So a very complicated thing, and if you want to avoid it, that shows the importance of making a will. So this was the class 1 legal heir which I have defined. Then class 2 legal heirs. Nobody, assuming there is nobody out of this 16 relations, then what will happen? Then here, if you can appreciate, father is not here. Class 2 legal heir, the first person is father. So if none of the 16 people are there, then the property will go to father. If father is not there, then it will go to his siblings. Siblings would include his brother or his sister, right? So if father is there, nothing will go to siblings. If father is not there, the property will go to siblings. If siblings are also not there, then it will go to the grandparents. For example, dada, nana. So from grandparents, either from father's side or mother's side. So it will go to his grandparents, then his parents' siblings. So if the grandparents are not there, then parents' siblings. So, okay, my father's brother or my father's sister, it will go to them. Then I hope you have understood this. If none of the class 2 legal heirs are there, then it will go to the other relatives from the father's side. If nobody is there from father's side, it will go to the relatives from mother's side. And nobody is there, then it will go to the government. I have taken some case studies, but I apologize that I have written the names in Hindi. So I would because in northern India I was taking this lecture. So I would just translate and show it from by way of example. All these things we have discussed from the perspective of intestate male, a male who is dying without making a will. Now, situation 1, a person dies leaving behind the following relatives: his mother, his father, his wife, his son, his daughter, and the last one is his daughter-in-law. Now, my question is, you all can write in your the answers in your notebook or somewhere, or you can decide who will be the owner and what share will everybody get. His mother is there, his father is there, his wife is there, his son, daughter, and daughter-in-law. Everybody is there. So who will get what share? You can even answer it in the question answer tab if you want. That can also be done. So mother is there. Mother is class 1 legal heir. Yes, absolutely, she is class 1 legal heir. Father, is he class 1 legal heir? No, father is not a class 1 legal heir. Wife, yes, wife is class 1 legal heir. Children, yes, definitely they are class 1 legal heir. Daughter-in-law, no, because the son is alive. Unless the son has demised before the person, intestate male, daughter-in-law will not get anything. So mother, wife, and children, they'll be entitled to the share. Father will not get anything, or daughter-in-law will not get anything unless the son is alive. So this was first case study. Second case study, in this case, the intestate male is expiring, and in his case, his wife is there, his brother is there, his sister is there, his daughter-in-law is there, and his son is expired before his daughter, before that person. So his widow daughter-in-law is there, and we have his deceased daughter's son. His daughter is also expired, and we have his son. So who all will be entitled to the share? His wife, his brother, sister, his widow daughter-in-law, and his grandson from his deceased daughter. So I believe you all are ready with the answers. I'll confirm the answers to you. His wife, definitely she'll get. Brother and sister are class 2 legal heirs, so they'll not get anything. His widow daughter-in-law, definitely, because his son was entitled to the share. Since his son is not there, the daughter-in-law will be entitled to the share. His daughter was entitled to his share, but his daughter is not alive, so his grandson, his son of his deceased daughter, will be entitled to the share. So these 3 people will be entitled to the 1/3 share from the property of their intestate male. Third example, which I am covering here, now no class 1 legal heir, for example, he has 2 brothers and 2 sisters and 1 grandparent, Nana, his mother's father. So who will get the share in this case and how much? So as I said, siblings are first and then grandparents come to under the class 2 legal heirs. So when the brother and sisters are there, they'll get everything and nothing will go to the grandparent because it comes on a lower stand in the class 2 legal heir pyramid. So both the brothers and both sisters will get equal share. Everybody will get 1/4 25% share in this case. Now another example. Now this is a bit complicated example. A person who is dying, his mother's brother's son. So it's both the cases are cousin, but one cousin is from the mother's side and another cousin sister is from the father's side. Who will get the share? So definitely we discussed agnates are first before cognate. So uncle's daughter from father's side will be entitled to the share and uncle's son from mother's side will come below. So when there is some heir apparently alive from father's side, everything will go to him. So your uncle's daughter will get the share and from the father's side, agnates will get. Fine. So now, as Mr. Pannaraj had said, income tax is something which troubles us many times. Income tax perspective, we see in income tax, child includes a stepchild, but that principle will not apply to Hindu Succession Act because Income Tax Act includes child as a stepchild. Hindu Succession Act includes only a naturally born son or an adopted son. So unless he is a naturally born son or adopted son, he will not be a class 1 legal heir. So a stepson through first marriage of the wife cannot succeed as a legal heir to the estate of male as in the capacity of class 1 legal heir. So a stepson is not a class 1 legal heir. Then, now this we had discussed regarding the class 1 legal heir or the heirs of the male. Now with regard to female, there is a bit different law which we need to understand. In case of female intestate Hindu, the property will be distributed in the following capacity. If the son, daughter and husband, if the children and husband of the deceased female are there, everything will be distributed to them in equal ratio. If her husband is not there and her children are not alive, the property will go to the heirs of the husband. If nobody alive from the heirs of the husband, how will you determine who is the heir of husband? You go to the class 1 legal heir, class 1, class 2, agnate, cognate. So chances are there that anybody would be there. If nobody is there from husband's heirs, then the property will go to her parents. If nobody is alive from her parents, then the property will go to the heirs of her father. And if nobody is there from her heirs of her father, then the heirs of her mother. So the property will accordingly be distributed in the following way. So first you need to see if the son, daughter or husband of the female is there or not. If they are not there, it will go to the heirs of husband. If no heirs of husband, then her parents. If her parents are also not there, heirs of her father and heirs of her mother. So this is a normal chart in case of female intestate Hindu who does not make a will. Then next, female intestate, what can she distribute and what she cannot. So her absolute property is something which she can freely distribute to anybody in the manner which she likes. What do you mean by absolute property? Property which she has received through inheritance or in partition in lieu of maintenance by way of gift or own skill or purchase. She can freely give it to anybody whom she wants in any way. But then there is some exception to this. If the female dies without making a will, then it needs to be seen whether she has children or not. If she does not have children, some special rules are there which will be applicable. Another thing, whatever property she is trying to give away, whether she has a clear right over that property or not, that is also very important to see. In India, there is a concept of life interest. Life interest, what do you mean by life interest? something which is given to the person to live only. So it is not that she has an absolute right over it. For example, there is a very celebrated case of Sadhu Singh versus Gurdwara Sahib Narike. There was a gentleman, Sardarji. That Sardarji did not have any children. So what he wrote in his will, he had a huge mansion with him. He said, after me, my mansion will be there for my wife to live in. She has a life interest. Till she is alive, nobody can sell or do anything with this house. But after my wife expires, after she dies, this property will go to my nephews. So the nephew of that gentleman who wrote the will was Mr. Sadhu Singh. So it was written in his will that after my life, my wife will live in the house for her life. So she had a life interest. But after she dies, it will go to my nephew. Now that person died and her wife used to live in the house. After many years, her wife thought, why to give it to anybody? It is better that I wish to donate this mansion to the Gurudwara. So she wrote a will and donated the house in which she was living to the Gurudwara. The Gurudwara took the possession of the house, Gurudwara Sahib Narike. Then there was a case filed by the nephew. The nephew said, my aunt only had the life interest to stay into it. She cannot will it away. She did not have a right to sell it or donate it or do anything. The matter went to court. Ultimately, it went to Supreme Court, and Supreme Court said yes, the nephew is right. The woman did not have any right to sell it away or donate it or do anything. She only had a right to live in it. There was a life interest, so she could not give it to anybody whom she desired. And then the possession was given it to Mr. Sadhu Singh, and it was said that you are the real owner according to the will of your uncle. So your aunt cannot give it to the Gurdwara. So this is an important concept. So one needs to know what he can give in the will and what he cannot bequeath in the will. This is very important. So there is this concept of life interest which we need to keep in mind. Then there is another very important concept. When a female dies, in those cases, when a female dies without making a will and she does not have children, then there is a specific different rule for the inheritance of property. For example, when a female dies without making a will and if she does not have children, then the property will revert back to her father's heir if the property was received from father. I'll give you an example. The female got a beautiful ornament from her father, or she got a house from her father, and she does not have a children. So when she dies without making a will, the property will not go to her husband, but it will go to her father's heir. Why? Because she does not have any children to succeed. If she has got some property through inheritance from her husband's side and she does not have children, the property will go back to the relatives of his husband. It will not go to her father's side. So this is important. We need to understand, if the female intestate dies without making a will, the property will go to, and if she does not have children, then the property will go to her where it came from. If it came from her parents, it will go to her parents. If it did not come through her parents, if it came from her husband's side, it will go to her husband. But if it is a self-acquired property or something like that, then as per the rules which we have discussed below. Now, let's understand this again through a case study. Now, fortunately, I've written it in English. So, where an intestate female dies, leaving behind the following legal heirs, who will get the property out of this? She has her husband, a son, daughter, her mother and father. So, I think you all will be ready with the answers. Ultimately, her property will be given to her husband, son and daughter, and mother and father will not come right now. Why? Because the intestate female, first, if the husband, son and daughter are there, they'll get equally her property, 1/3, 1/3, 1/3. Right. Now, another case, another example. In this case, the intestate female dies. She leaves behind her ex-husband. she is a divorcee and her mother and father. So who will get the property? Since she is a divorcee, she will not, her husband will not get anything. Everything will go to her mother and father in this case. Because when there is a divorce, the relationship of husband and wife comes to an end. So she does not have any husband and the property will go to her mother and father. Now, in this case, a female is dying, a female who dies, leaving behind her brother-in-law, his husband's brother. They were in Hindi, we call it. So her brother-in-law is there, and on the other end, his sister-in-law's son is there. So who will get the property? Brother-in-law or sister-in-law's son? See, it was siblings. So brother-in-law is there, and sister-in-law, if she would have been there, she would have got. But these are class 2 legal heirs. So if any one of them is there, brother-in-law is there, so he'll get everything. Sister-in-law's son will not get anything. So this is important, which we need to keep in mind. And the last one is her husband is there, her uncle is there, her father's brother is there, her father's sister, Bua, is there, and her husband's sister is there. So who will get the thing? Now the property, in this is the case where the female is died without making a will and she does not have any children. So in this case, the property will be given to whom? So we need to see she does not have any children and the property is received from her father. So it will not be given to her husband, her husband's sister, but the property will be given to her uncle and her aunt. Yeah.
One question here, sir.
Yeah, please.
If a female member, her husband is lost and she gets a remarriage,
Right.
who will get the property? Her husband.
See, if she is remarried, and if you consider this example, even in this her husband is there. So unless she has children, if she does not have children, then this rule of inheritance will apply. But you mean to say that she is divorced and she is remarried and her property from her ex-husband is there, received by her. See, in that case, that property will become her absolute property. As we have discussed, give it the way she wants. So it will be distributed to her new husband. He will get the property in this case. Whatever property she receives.
In case of death of husband and she getting married, another marriage.
In case of death of her husband, she will get her share as interstate. And once she gets her state as interstate, that will become her absolute share. After that, if she remarries and her second husband also dies unfortunately, the property will go to as per the normal rules. This rule of does not have children. It would again depend whether she has children or she does not have children. Assuming she does not have children, then the property will go in the capacity of her husband and husband's heirs in this way, because it has not come from her ex-husband's her parents. So that rule will not apply here. Am I clear? Right. So now, moving ahead, lastly, we discussed that when there is nobody to claim, then the property will go to the government of India. Now, one very important issue, why this concept of interstate is troublesome, is when there is an interstate death, you need to go to the district court and obtain a letter of administration to deal with the property of the deceased, and you need to get a court appointed executor who will deal with all this thing, administrator. And for getting all these documents, you need to produce the death certificate, list of legal heirs as per the Hindu Succession Act, value of the estate. You need to move an application statement through the lawyer. You need to give a public notice calling the claims and objections, and then the property can be divided, distributed interstate. So this is a troublesome process, and because of this process, the problem which comes if the business may get held up. So to avoid all this and to avoid the litigation amongst the successors, the difficulty in transmission because there may not be consensus. So the best way is to write a will. We'll now move to the will. Will solves many problems in this way. So coming to testamentary wills, what is a will? See, we all know will is something which comes into force after the death of the person. A will is the best way to express the opinion. The will speaks from the grave of the deceased. So a person, if he wants to make a distribution as per his discretion, see, after Hindu Succession Act 1956, everything is the property of that person. Now the concept of ancestral property has gone. So now anything if he wants to bequeath, everything has come in his personal capacity, his independent capacity. So he has the right to give everything. So when a person wants to distribute as per his own discretion, the way I want it, not as per the common law, so that can be done through the instrument called wills. Some important terms before we come to the will. Who is an administrator? Administrator is a person which the court appoints. Many times we make mistake of not writing the name of executor in the will. When executor is not mentioned in the will, in case you need to again approach to the court with the will and ask the court, please appoint an administrator for our will. So that is a mistake commonly made. So always mention the name of an executor in the will so that you don't need to go to the court again to get an administrator of your will. So administrator is the person with the, appointed by the court to administer the estate of the deceased. Second very important concept, which is most important for people of Chennai, Madras High Court, probate. Probate is something where a court is approving, the High Court approves the will. High Court gives their sanction over the will, which is applicable. Now, interestingly, probate is a concept which is not all across the country. Probate is applicable as per the old presidency laws. Probate is applicable to the people who come under the jurisdiction of Madras High Court, Bombay High Court, and Kolkata High Court. So these three high courts, they don't ask about all the other high courts. The concept of probate is applicable to people who deal with the concept, who are under the jurisdiction of Madras, Bombay, and Calcutta High Court. Probate is applicable to those people. Many times it happens that you write a will, you get it registered, but then later on you want to make slight modification to the will. So instead of writing a whole will, again, you want to make an amendment instrument, and that is a codicil. Codicil is a small document amendment deed to the original will, which may be registered, may not be registered. So when you don't want to repeat the whole will by itself, you can make an amendment to the will by way of a small document which is called a codicil. So codicil is that kind of document. Then there are other documents like letter of administration of succession certificate, which are issued by the district or civil courts, normally in case of intestate death. Then coming to the governing law of testamentary will. The statute which is governing the will is Indian Succession Act 1925. What is the will? It is a legal declaration of the testator's intention. See, as a testator, I am making will. So what I want, the manner in which my property should be dealt with after my death is the intention which is written in the will. But it will only become applicable after the death of the person. It will become effective only after the death of person. So till the person has died, he can make n number of wills he wants during his lifetime. He can make 10 will, 20 will. Every day we can make a will. There is no bar. The latest will shall prevail. So will is a document which only comes into force after the death of the person. Now, who can make a will? So anybody who is competent to contract can make a will. So what are the conditions? He should be a major person above 18 years. He should be of a sound mind. Sound mind, he should not be intoxicated. He should not be in a situation, he may not make a will when he is not in his senses. So an intoxicated person or an insane person cannot make a will. Deaf, dumb, and blind, they can definitely make a will if they are in the knowledge of what is written or what is in the will. So they can make a will because they are sane, they are not debarred from making a will. There may be circumstances when a person gets some attacks. So in those cases, insanity attacks. So in those cases, if he's in the interval of sanity, he can make a will. So how to decide? So you may obtain a doctor's certificate when he's signing a will. So the doctor will examine him and certify that
Sir, you're not audible, sir. Sorry, you're muted, sir. Hello. You muted your mobile, it seems so.
yeah, sorry. Am I audible now?
Yes, you're audible, sir. Past 30 seconds lost, sir. Sorry.
So uh, uh, I'll repeat with this slide.
Yeah,
Why
yes, sir,
to
please.
make a will?
Please, please. Thank you.
Right. I'll again come with this slide. Why to make a will? So it gives you complete discretion on distribution of your property after the death. It reduces the succession disputes. It is a great tool to reward the people who have cared for you. Many people, there may be people who may not be your close relatives, but they care for you for your life. So definitely they deserve something, and you can reward them by making a provision in the will. And it is always advisable to make a will even at a younger age, because people may die at this COVID has shown us, pandemic has shown us young deaths. So people are already saddened by the death of their young relatives, and you may not want them to suffer more by way of interstate succession. So it is always advisable to make will at a younger age. Now, coming to how to make a will should always be written, because the privilege of making oral will is only given to soldiers who are fighting at the front. And in case of Muslims also, there is a concept of oral will, but otherwise it is always advisable to have a will in writing. How to make a will? So you need to make a will in writing and designate the beneficiaries whom you want to give the property. Then it is advisable to make the will very detailed. Or a detailed will is always advisable because it always explains. There may be situations where somebody may doubt your will. Some disturbance coming, sir. Hello. Am I audible properly? So I was discussing that the will should be detailed one. Why? Because if somebody doubts the will on okay, my father has not left me anything and left everything to my brother. So if the will expressly provides that the brother took care of the father and therefore he wanted everything to go to his son, so that would justify that okay, the will is not made under any influence or something like that. So definitely it is always advisable that the will should be detailed one. Then what are the essentials in a will? So first and foremost is the will should be dated. Why? Because it is the last will which always prevails. So will must be dated. Then the signature or thumb mark identification is required. At least 2 witnesses are required when the will is made. And one very important thing, I am coming in the later part also, the person who has been made as a beneficiary should not be made as a witness. For example, if you are giving the wealth to your wife should not sign as a witness, because there are provisions which make the will, the benefit, the legatee invalid. For example, if you want to give 1 crore rupees to your wife in your will, and your wife signs as a witness in the will, then your wife's, the bequest which you have made to your wife will become illegal. She'll not get anything. There are provisions to this regard in the Indian Succession Act. So always ensure that the witnesses are person to whom you do not give anything. So that would remove the conflict of interest. Then always appoint an executor, because as we have discussed, executor is a person. If you do not appoint an executor, your beneficiaries will have to go to the court and get an executor appointed. So always write a name of an executor. The executor should be younger than the testator who is making a will, because there may be situation that the executor may die before the testator. So it is always advisable to have an executor who is a younger person than the testator. Now, who can be made as a beneficiary? Anyone, whatsoever, whomsoever you want, you can make a beneficiary. Your relative, your friend, your employee, your servant, your chartered accountant, your lawyer, any stranger, anybody can be made as a beneficiary. I'll share 2 examples, 2 beautiful examples. A Mumbai-based couple used to love their dogs, so they made a trust and they bequeathed everything in favor of those 2 dogs, almost 5 crore rupees. In US, a very famous designer, Karl Lagerfeld, he bequeathed his property worth 2,700 crores to a cat whom he loved. This reminds me of a beautiful thing. See, the beauty of Indian culture, if you see, Mother Teresa used to say that in India, a person who is suffering from leprosy in Calcutta, who is a very poor person, is still happier than a person who is staying alone in the West. So loneliness is the curse in the Western society. So even in India, if somebody is so poor, still he is more happier. This is shown by this example, that a US-based designer bequeathed everything to his. He did not give anything to his ex-wife or his children, but everything he left to his cat. So that shows the example. So ultimately, we can conclude that anything can be given to anybody. So you can make anybody a beneficiary. There is no precondition for that. Now, one important thing which we also keep into mind now is the digital age. We have our email credentials, our bank account credentials. So it may happen that a person dies, his Google account, his Gmail account may have details of other precious assets which the person may possess. So what to do with those assets? So you may apply to Google ki please provide us the password of that person. Google may ask for a succession certificate. So if you have a will and if you provide that all my digital assets and credentials should be given to Mr. So-and-so to manage, or to Mr. So-and-so who is the executor. So in those cases, it is easier that when the will copy is submitted to Google or Facebook or those cases, or even in cases of Bitcoin investments, you are through some broker, you have purchased Bitcoins and those Bitcoins are in your digital account. So the ID password to trade the Bitcoins or to have the Bitcoins, you can mention in your will. All my assets, whether digital, non-digital, ID, password, credential, everything will go to so and so. So provision for these digital assets also should be made in the will nowadays. That is also become very important. Then executor, as we discussed, normally for cities where this probate concept is there, you can it is very common to make the spouse as an executor. Why? Because she'll have to apply for the probate to get the property, and to apply and get the probate is a Herculean task. So your wife, it is always advisable to make the spouse as the executor, so that since she is interested in the property, she would not mind and going to court and doing effort. And if you appoint somebody else, the person may not be that much interested without some remuneration to go to the court and obtain probate and do things. So always a beneficiary and executor can be a same person. CA or consultant, unless they provide for a fee in the will, do not become an executor, because it is a very Herculean task and you should not do it for free. So if a CA or consultant is becoming an executor, that should be for a fee, not FOC. Unless the person is really your near and dear family or friend. If he is your client, please make a provision of the fee in the will itself. Then executors, you may appoint a primary and secondary executor. Why? It may happen that a primary executor may demise before the person. So again, then you will have to change the will. So it is always better that you provide a primary executor and a secondary executor. Okay, this person will be executor, and in absence of this person, Mr. So and so will be your secondary executor. He will become the primary executor. Who can become an executor? So a person who is capable of making a will is also capable of becoming an executor. But one very important thing is the willingness to become an executor. So whenever you are making or writing somebody as an executor, please ask that gentleman that will you do the execution of my estate? Because we have seen cases that after the death of the person, when we approach the person, okay, he has made you executor. He said, I don't want to become an executor. Then we had to again approach to the court to get a executor appointed by a court. So it is always advisable to consult that person. Okay, I want to make you as an executor. Please give your consent. And there are instances where a written consent is also obtained from such person. Then moving ahead, this is very important concern. As I said, that section 67 of the Indian Succession Act, now this does not apply to Hindus, but it would apply to Christians, Parsis, or all the non-Hindus and Muslims. This says that a person who is a beneficiary in the will cannot be a witness. If the person becomes a witness, the bequeath made to the beneficiary will become void. So example, I am giving 1 crore rupees to my wife in my will, and if she signs as a witness, then she will not get that 1 crore rupees at bequest. It will be distributed in the interstate manner. So it is always advisable. To make witness a party who is not a beneficiary in the case. Then revocation by marriage. This is very important. Section 69 of Indian Succession Act specifically provides that if a will is being made before the marriage and then the person marries, in those cases the will automatically gets revoked. Yes, there is an exception that this will not apply to Hindus and Muslims, but for Christians or another people who have made a will, in those cases that will automatically get revoked on the date of marriage. Why? Because it is considered that marriage is a very significant event in the life of person, and the beneficial interest, everything changes significantly. So section 69 of Indian Succession Act expressly provides that revocation will happen of a will which is made before the marriage of the testator. So please keep in mind, if there is any will before the marriage, you make another will, you revise the will after the marriage, because that earlier will might have got revoked by way of the event of marriage as per section 69 of the Indian Succession Act. Another important thing which we should keep in mind is registration of will. Registration of will is very, very, very important. It is not compulsory, but it is important to establish the genuineness of the will. It raises a strong presumption in case of genuineness of the will. Yes, registration is not compulsory. I'll give you an example, one very beautiful case study. 1st April, a person made a will and got it registered. On 5th April, he made another will, but he could not get it registered, and 6th April, he died. So which will prevail? The registered will which is made on the 1st April, or the unregistered will made on the 5th April? The law is the later will prevail. So the will which is made on the 5th April, though it may be unregistered, but it will still prevail because it is the last will. Unregistered will can be superseded by a subsequent will. If you cannot get it registered, get it notarized at least. That is something which you must do it. Now, what are the advantages of registration? One very important advantage which we can see is it is a legal heir proof. See, when you go to income tax portal for registration of a legal heir, you need to take a legal heir certificate or surviving member certificate from Revenue Authority, family pension certificate, letter from bank, and registered will. So if you have a registered will, nothing doing, you produce the registered will, you submit it to the income tax, and your person will get registered automatically as a legal heir. So this is very important thing. If there is a registered will, the troubles which you get in income tax in getting the legal heir registered would reduce. So this registered will is a very important document, and it, apart from this, it raises a very strong presumption that this is a genuine will because the person signed before the sub-registrar. So registered will is something very important, advisable, though not compulsory. Now, coming to a very beautiful case of undue influence. There was a case of Mr. Mahesh Kumar. In this case, this is a Supreme Court case. In this case, what happened? A brother challenged his father's will. His father was living with his son. One son used to take full care of the father, used to treat him properly. Another son used to ignore the father. He did not live with his father. He never called him. He never took care of his father. He was extremely hostile towards his parent. And the parents logically and very rightly gave everything to his son, who used to take care of the parents. The another disgruntled brother went to court. He said this will is not a valid will. This is illegal. Court asked, it is a registered will. It is a signed will. So you want to say this is a forged signature? Well, no. I am challenging it because my father was not competent to contract because he was under the influence of my brother. Court said, how can you say that? He said, my father was living with for so many years with my brother. My father was of old age and frail health. So my brother was obviously able to exercise his influence. Court said, you cannot regard this as influence. This is something common sense. If your brother was taking care of his father, though he was of old health, but he was not suffering from any mental illness, so that you can say that this was an undue influence. And court said that your father was of a good mental health, and it was very commonsensical for him to give everything to the person who took care from him, who took care of your parents, and took care of all his needs. So there is nothing unjust in or wrong in giving everything to him, and the claim was rejected. So this shows us that people may challenge your will on the grounds of undue influence, and it is always advisable to write in will logics. For example, in another case of Madras High Court itself, it was held by the court that see everything was given to one person and not given to another person, and no reasoning is written. So this creates a doubt on the will. So, for example, if a person has given a huge wealth to his daughter at the time of marriage, so he does not want to give more to her daughter now after his death, so he can write in the will that okay, I have given 5 crores and I have spent 5 crores at the time of marriage of my daughter, and I have given her so and so. So I am now giving only so and so, and since I did not give anything to my son, now I am bequeathing everything to my son so and so. So if you are giving a logic and reasoning, that makes your will more stronger and less prone to this kind of allegations and challenges of undue influence. So it is always advisable of writing some logics when you make a will. Then one more important concept which is developing nowadays is of a joint will. See, firstly, I would never advise to make a joint will. Why? because what happens in joint will, if husband and wife write a single will and one of them dies, then the other will be stuck. He cannot change the will. So in normal circumstances, it is always advisable to make separate wills for both. But then when you intend to have some reciprocal promises, if husband believes that wife may remarry after his death, or wife anticipates the same, or husband may intend that, okay, after my death, my wife may make arbitrary disposal of the wealth. So if you want to bind each other, it is always advisable to make a joint will kind of thing. So after the death of one person, if you want to change it, both will have to change it. One person is not competent to change it. So after the death, the wife will be bound. The will not be subject to change. So this joint will also is an interesting and important concept which is being done. Then there may be instances when the person who has made, for example, Mr. X has made the will and has written that his son will be his legal heir, but may happen that his son may die first and the father would die after him, but he could not revise his will. In this case, the estate will devolve on the legal heirs of the deceased son. Then, one very important concept, what can be willed and what cannot be willed. So all the self-acquired properties can be willed. All the properties which are acquired by inheritance or gift, it can be willed. Share in the properties of HUF. If I am a member of an HUF, I have a share. So my share, I can will it away to, okay, I want to give it to him. But I cannot make a person a co-partner in my capacity. The other person will have a share in the will, share of HUF. So he has the entitled to receive a specific amount, but he cannot get the rights which I have as a co-partner in the will. I cannot give those rights to him. I can just give the money. I can give the share which I enjoy the HUF. What cannot be willed? Tenancy rights are subject to state tenancy rights that cannot be willed. Under Mohammedan law, Shariat law is there. So if a Mohammedan wants to bequeath, he cannot bequeath more than 1/3 of his property through the will. So if I have 3 crore rupees, only 1 crore rupees I can give it to my children or anybody whom I want if I am a Mohammedan, and remaining 2/3 will go as per the Shariat law only. Now there is an exception that after the death of person, he has given everything to say some trust, a Mohammedan person. In those cases, what will happen? That the person who has got the property, his legal heirs may give a consent, okay, we agree with the bequest made by the deceased person. But that consent will only be valid only if it is obtained after the death of the person. Because if during the lifetime of a person, he may ask everybody to please sign on my will and give your consent that I am making so and so bequest. So he may exercise such position. So that is not valid. If a Mohammedan makes a will, he can only give 1/3 of property. Regarding 2/3 of property, that bequest is only valid when that bequest is made and all the legal heirs after the death of the person give consent to such bequest. Then, very important, I am partner in a firm. I write in my will that after me, my son will become partner in the firm. Will it happen? No, it will not happen, because partnership deed is required to be seen. If partnership deed you write that Mr. So-and-so is made partner, or his legal heir whom he specifies in the his will automatically become a partner. Unless that specific clause is written in the partnership deed, his legal heirs will not become a partner. This is very important, because the legal heirs to become a partner, there has to be succession has to be provided in the partnership deed. If it is not provided, then unless all the partners resolve and agree, you cannot be admitted as a partner. So, okay, if I am writing my son will become entitled to my partnership share, so the amount which is lying in my capital, he can claim that amount, but he cannot become a partner unless the deed provides it. So if you want to succeed succession of your business, so your partnership deed should have a succession clause where you need to write that, okay, my successor whom I designate in the will become the partner after the death of the contractee. Then these are some common clauses: name, age, address, religion, list of relatives, discharge of obligation, residual estate, execution, safe custody, revocation of all. These are some common things which are in the will. So you need to proper identification: who is writing the will, age, address, religion is very important. Religion needs to be mentioned. Then this is my last will, so I revoke all the earlier wills. Here are the relatives, list of relatives. Then first and foremost, appointment of executor. He is my executor. You pay all my obligations first, and then give my bequest, my property distributed, legacies and bequests to the persons. Residual estate, apart from this, anything remaining or any new thing which I buy in future will be given to so and so. Testimonium is my signature. Execution, witnesses, who will be the witness, and safe custody of will. All these are very important. Now, codicil, we have already discussed. Codicil is the document to amend the will when you don't want to write a fresh will. Stamp duty. There is no stamp duty applicable in case of will. The Indian Stamp Act exempts such transaction from stamp duty. A will can be made even on a plain paper. There is no bar for it. Probate. Probate is a document which is granted for the administration of the estate. So probate is something very important, and it creates great problems in many of the scenarios, because a will has to be approved by the High Court. So Madras High Court in your case will approve the bequest. So probate is required, and it can be only granted to an executor. So executor has to be written. So probate will be a conclusive evidence of the execution of the will, all the legacies and legal character of legatees, by confirming the validity of the bequest in the will. So probate is something very important document. Now, a probate is not compulsory in case of Hindus and Muslims, unless they reside in the cities of Mumbai, Chennai, and Kolkata. Will executed in Mumbai, Chennai, Kolkata will be required, or where the property is located in these cities, probate is required. A nominal fees is there. Maximum fees is around 75,000 for probate in Maharashtra. A similar amount would be there in Chennai also. There is no time limit for applying for a probate, but a delay beyond 3 years of the death. Suppose the gentleman expires, and after 3 years of his death, his will is taken for probate. In those cases, court may ask for a reason why there is a delay in the application for probate. So then this is also important, which needs to be taken care of. Abstain to contest a will. I have written a will. After death of a person, I have given everything to my servant. Now my son goes to my servant that, see, my father has written everything to you. I know this will is genuine, but you give me 5 lakh rupees. Otherwise, I'll challenge the will. So the gentleman, the servant gives, okay, take this 5 lakhs, go away. Don't write that you will not challenge the will. Now, the person who has got this 5 lakh rupees not to challenge the will, whether it is taxable or not. So can it be taxed under Section 56 of Income Tax Act? There is a decision of Bombay Tribunal, Parvez Poonawala, 138 TDJ 673, where it is clearly held that, see, this is not taxable, this is a capital receipt. You cannot say that this is without consideration. The gentleman has promised that he will not challenge the will. So that is a consideration of not challenging the will against which this amount is received. So this amount is not taxable in law. Then there are some fake myths which we need to be busted. One will, that will must be made on a stamp paper? Absolutely not. It can be written on a handwritten on plain paper also. Legal format to be followed? No, there is no legal format. It can be written in a very simple English or Hindi or any vernacular language. Will cannot be changed once made. Absolutely wrong. Will can be changed daily. N number of times it can be challenged. It is effective in a person's lifetime. No, it is not effective in a person's lifetime. It only comes into force after the death of the testator. In a will, you cannot exclude your close relatives like your son, your wife, or your mother, father. No, in will you have complete discretion. You can give it to anybody, to anybody. You can leave your wife, you can children, you can give everything in charity, you can everything to your servant or your friends, anybody. So this is the important concept. Then will need not be dated. No, absolutely wrong. Will must be dated because the last will prevails. So how will you decide which is the last will? So it must be dated. Nomination prevails over the will. No, it is not the case. Will prevail in all the cases. Nomination is what? It is just a stopgap arrangement. It will not prevail. We will discuss about nomination in coming slide also. A married woman cannot make a will. Absolutely wrong. Any woman, every woman can make a will. There is no bar that married woman cannot make a will. No need of witness. Witness is a must. At least 2 witnesses must be there. Marriage revokes a will. Yes, absolutely correct, but not in all cases. This is not true in the case of Hindus. In other cases, marriage definitely revokes a will. So once the person is married, his all earlier will gets revoked already, except in the case of Hindus. So these were some myth busters which we have dealt. Now, before coming to the taxation aspect, I suggest we can take a 3 minutes break or 5 minutes break.
Sure, sir.
Right.
Silva?
So we'll right now it is 7:28. So maybe
Yes,
we'll take a 2 minutes break or 5 minutes.
yes, sir. We'll
7:35.
take a 5 or 10 minutes break as per your comfort, sir, and then we'll start again. You let me know, sir,
Okay.
once you're ready. You can unmute yourself and you let me know, please.
So we'll start at 7:35. I'll just mute
Yes,
myself.
fine.
Yes,
Fine,
please.
fine.
I'll share my screen till then, sir.
Yeah, 7:35 sharp.
Yes.
7:30. Anaraj.
Sir, I'll just give you the rights to that if you are ready.
Yeah.
I'll give you the rights 1 minute, and you can start sharing your screen. Yes, visible, sir. Continue.
Yeah. Thank you. So now we will come to some taxation aspects of succession planning. What happens, because this has become very important nowadays. We may have many clients who have demised, and we need to file their returns. So normally, what happens? How to do the taxation aspect work of such people? This is the way to register yourself as a legal heir. For example, I have opened my profile. If I want to get registered as a legal heir of Mr. So and so, I'll open my profile dashboard, my profile, go to representative assessee. You can see this representative assessee. Here I'll register as myself as a legal heir. And once I get myself registered as a legal heir, then I'll able to file. Once I register it, and then I log into my profile, they will ask me, you want to open your profile as a self, or you want to log in as a legal representative, Mr. So and so. So whenever there is a PAN number of the deceased person, I can log in into his PAN from my own profile, my own account, once I register myself as a legal heir. So in the new portal, I need to go to the dashboard, my profile, representative assessee, then these details will be required to be filled. PAN number of the deceased, surname of deceased, middle name, first name, date of death, bank account details of legal heir. Then you need to move ahead. Copy of PAN card needs to be attached. Copy of PAN of legal heir and the deceased both have to be attached. Copy of death certificate. Copy of legal heir proof from the below list. So now, how will you prove that you are a legal heir? So either you take a certificate from the court of law, surviving member certificate, family pension certificate, registered will, as I discussed. So this becomes very important. Then letter issued by banking or financial institution in their letterhead mentioning the person as nominee or joint holder. So if you are a joint holder or a nominee of the deceased, so that letter from will suffice to give you the right as a legal heir. So for the purpose of logging to the income tax account. So these details are required, which are required to be filed. So if you have a registered will, you don't need any of these documents. So commonly what normal people are doing, either they have a registered will, or then they obtain a letter from banking or financial institution if they are joint holder or a nominee. So normally spouses are joint holder in many accounts. So based on that letter also from the bank, one gets registered as a legal heir. Then, now understanding the taxation aspect is very important. From 1st April, now listen very carefully, from 1st April to the date of death, 1st April, if the person is died on 30th September, so the income from 1st April to 30th September, date of death, will be taxable in the hands of the deceased, but the return will be filed by the legal representative. So it is basically taxed in the hands of legal representative, but the PAN number will still be of the deceased person. From the date of death, from 1st April to date of death, 30th September, the income during this period will be taxed in the hands of legal representative, who will log in through his profile to the PAN number of the deceased. So it is indirectly taxed in the hands of deceased through the legal representative. So date of 1st April, the financial year, to the date of death, this income taxable in the hands of legal representative. Now, after the date of death, till the date of distribution, now there are two things. Either there is a will or there is not a will. So assuming there is a will and there is an executor, so from the date of death till the date of till which the estate is distributed by the executor, in meanwhile this period, the income will be taxed in the hands of executor. Now how will it be taxed in the hands of executor? So executor will have to apply for a separate PAN the pen will be in the name of estate of the executors of the estate of late Mr. So and so. So you will have to apply for a pen for the period in which the income arises till the estate is distributed. So there will be a new pen number, executor of the estate of late Mr. So and so, and the income will be distributed in income will be taxed in the hands of executor in that capacity. Now, if one wants to avoid this, what can be done? The executor may distribute the estate immediately on the death of the person, so that no income is arised between the period from the date of death to the date of distribution. The shorter this period is, no income arises, so no new pen needs to be applied. And after the estate is distributed, it will be taxed in the hands of the beneficiaries who have got the thing. So till date of death, the amount is taxed in the hands of legal representative in the pen number of the estate deceased. After date of death till distribution, taxed in the hands of executor, and after it is distributed, it is taxed in the hands of person who has actually got this. Now, what are the provisions? Now, these are the legal provisions when the succession is testamentary or intestate. When there is a testamentary succession, you have the executor, so it will be taxed in the hands of the estate of the executors of the estate of Mr. So and so. When there is no will, so there is no executor. In such case, when the wealth is not distributed soon, then there will be tenants in common. It is like an AOP where all the legal heirs are there, and since the amount is not distributed, so till it is distributed among everybody, it will be taxed in the hands of all the legal representative, all the legal heirs in the capacity of tenants in common. So this is important thing. Now, when a person dies, very important concept, you need to see a notice received by the person when he was alive will not become invalid after he dies if the proceedings are continued, because in those cases the legal representative will be substituted in the place of the person, since the proceeding, it all starts when the proceedings were there. If the person was alive when the notice was received, the proceedings will be valid, only the legal heir will be substituted, legal representative will be substituted. But if the notice is issued after the death of person, the person has died, after that a notice is issued in the name of the deceased, then the notice and all the proceedings are invalid. Thankful to the wonderful decision of Madras High Court, which even says to that extent that even if there was no intimation to the department and the notice is issued on a day when the person was not alive, the notice and the consequent reassessment proceedings are invalid, not valid at all. So you need to see if the notice was received before the death or after the death. Now, the provision of 159 applicable to legal representative says that when a person becomes a legal representative, he will pay tax on the income of the dead person when he was alive. So he will be required to pay all the amounts which the legal representative was required to be paid. Legal representative will pay any tax or earlier demand another some penalty or whatever which was pertaining to the deceased. But this will be limited to the extent of the property received from that person, and the assessment will be made in the like manner and the same extent as the person has not died. For example, the person who has died, now the assessment is made for that income on the legal representative. So the person, legal representative, will get all the losses, all the credits of taxes paid in or deducted in the name of that deceased person. The legal representative will come into play only till the point from the financial year till the date of death, not after that. So it is till the date of death, legal representative has a force, section 159, and after the death, it will be the cases of testamentary and non-testamentary. In that case, executor's role will be important. Now, when legal representative is there will be separate assessment of income of the legal representative and in case of the deceased. So if a person dies during the year, before the end of the year, there will be two returns which will have to be filed. Firstly, by the legal representative in the PAN number of the person. Second, by the executor in a new PAN, naming executor of the estate of Mr. late Mr. So and so. So there will be two return filed for a single year when a person dies. Then arrears of tax can be adjusted, can be recovered, but not in the individual capacity of the legal representative. Legal representative is a separate person, and legal representative in his capacity of legal representative is a separate person. So Mr. ABC, if he is also a legal representative, and if he is individual, there will be two returns, two assessment orders filed by Mr. ABC, one of his own, another in capacity as a legal representative. Now, legal representative is deemed to be a separate assessee. He will be assessed in the PAN of the deceased in the representative capacity. Now, executor, similarly, after the death, it will be rule of executor. The executor is also assessed in the separate capacity. If there is one executor, he will be treated as an individual. But it may happen that there may be 2-3 executors. There may be a big estate, so there may be 3 executors. In that case, they will be treated as an AOP. But that is only for the statistical purposes. Madhya Pradesh High Court in GB Set's decision has said that though it is an AOP for statistical purposes, but still he will get all the losses, tax credits of that individual. So the set off of carry forward losses of individual will still be available, though the status of the executors is an AOP. So this is to be kept in mind. It is only for statistical purposes the status is getting changed. Some other issues. Is there any capital gains when a person receives a property from a person who is demised? So if there is a will, the property will be through will. If there is no will, it will be intestate. But the person who is receiving the property, there is no capital gains. If there is a testamentary will, there is no transfer. Even if there is no testamentary will, it is transmission, not transfer. And capital gain is levied only when there is a transfer, there is no transmission. So this is important. There is no capital gain when you receive any property from a deceased through will, even though he may be a relative or he may not be relative. It does not matter. Any third person can, like Priyambada Birla's case, she gave everything to her chartered accountant who was not her relative, but then there was no capital gain in either end. Similarly, when the person who is recipient, if he receives something from a non-relative, it is taxable, but then there is an exception carved out which says that if the property or amount is received under a will or by way of inheritance, it is not taxable under section 56(2)(10). Then surrender to of right to contest a will. I have already discussed in Bombay Tribunal in Parvez Poonawala's case. It is held that any sum received by taxpayer for not contesting a will is a capital receipt. Another important thing, expenses of our probate. I got a property through a will. Now, for getting the clear title over the property, I had to go to court and I had to spend 2 lakh rupees to get it in my name. So that were expenses incurred for probate of a bill. Now, when I am selling the property, I am claiming this 2 lakh rupees as expenses. No, they cannot be claimed because they are not allowable expenditure. These are capital expenditures which are not allowable. There is a decision of PC Malik versus CIT, as old as 6 ITR, held by Privy Council. So expenses for probate are not allowable expenditure normally. Then cost to previous owner. If Mr. X gave it to me through bill, the cost at which Mr. X purchased or the value as on 1st April, whichever is higher, shall be allowed to me. The period of holding I'll get from Mr. X. Mr. X, who was the original owner, if he has given it to me, the date when he himself acquired it, that period will also be added to my period of holding, and I'll get the benefit of indexation and all those benefits I'll get. So cost to previous owner as well as period of holding of previous owner will be allowable to me when I receive the property through a will. Then all this was regarding will and taxation. Now coming to a very important concept, HUF, Hindu Undivided Family, succession planning. through Hindu undivided families. So friends, I do not call HUF as a Hindu undivided family. I call it headache unlimited. Why? Because see, HUF for many purposes, it is not considered as a person. For example, in Rasiklal's case, Supreme Court has held that HUF is not a person to become a partner. So if a partnership firm has a HUF as a partner, they have said HUF cannot become a partner. Even in LLP, MCA has issued a specific circular that HUF cannot become a partner. So HUF was earlier used only as a tax plan and divide. In today's time, the HUF has lost its relevance because the nature and kind of business is not as such, which earlier HUF used to propagate. Now, HUF cannot become a partner. If you buy a property, immovable property in the name of HUF, it will create more problems. The title will become disputed, and then there are various issues. So we should avoid. Yes, but with regard to movable properties, if there is some tax advantage, people may do some planning, but not from immovable properties at least. Then, how does a HUF become? How do you form an HUF? I'll consider or I'll discuss some very important concepts of HUF which are relevant in succession planning. So, as per Hindu Succession Act, when a male marries, an HUF is created. But as Mr. Pannaraj said, income tax is different and Hindu laws are maybe different. So income tax says that no, when you marry, you do not make a HUF. HUF is formed when at least one child is born. So at least two co-partners should be there, and two co-partners will become when one child is born. So as per Hindu Succession Act, a family starts on marriage, but Income Tax Act wants at least one child, could be a son or daughter anymore. But HUF will be created only when at least there are two co-partners, at least one child is born. After 9 September 2005, a wonderful amendment has come which says that a daughter has equal rights as of a son. A daughter can demand partition. Now there are some differences. See, you need to understand the concept of co-partner. If a person has made an HUF, if he marries, his wife becomes a member. She is not co-partner. Co-partner is out of birth. So if a person is born in the family, he will be a co-partner. But if the person marries, it will become a member, not a co-partner. So a daughter is a co-partner. Only a co-partner can demand partition. So daughter can demand partition, but your daughter-in-law cannot. Your daughter is married, she is in another family, but if she is the eldest child, she can become a karta. She can, even though she is married in some other family, she will still continue to be part of your HUF and she can demand partition. But your daughter-in-law, who is in your family, she can demand partition in her father's family, but not in your family, though she is part and parcel of your family. Then, one very important principle which is emerging, see, your grandson will be part of your HUF, but your daughter's son, can they also become part of your HUF? See, now the view which is coming up is daughter has equal rights. So if some son can become a member of HUF, why not daughter's son? She has equal right. If your son's wife, your daughter can become a member of your HUF, your daughter's husband, your son-in-law can also become a member of your HUF. So after this amendment, this new theory is also coming up, which we may keep in mind. Then, as discussed, Vinita Sharma versus Rakesh Sharma, Supreme Court, daughter must be alive on 9 September 2005. If she is alive, she will have equal right over the father's property or the HUF's property, but the HUF property must exist on 9/9/2005. If there is a partition, written partition, oral partition is not valid. If there is a written partition, registered written partition of the family before 2005, then daughter will not be able to claim anything from HUF. But if there is a partition, if there is no partition, then daughter will have equal share in the HUF if she is alive on the 9/9/2005. Then the eldest child will become karta. He may be son or daughter, nothing. They can become a karta, no issues. Daughter can also become a karta. Even a married daughter who lives in another family can also become a karta. If she does not become, she can waive the right, and the next son or daughter can become a karta. Now, a very interesting case study. Mr. X, his wife, and his minor child is there. Mr. X dies, his HF is there. So now, who will become the karta in this case? See, his wife is a member. Member cannot become a karta. Only a co-partner can become a karta. So wife cannot become a karta, and children are minor. So they cannot become a karta. So what will happen in this case? There is a decision of Supreme Court, Shreya Vidyarthi, which says that the wife will become a guardian manager. She will be equivalent to a karta. She will have right to deal with the property, but she cannot become a karta. She will be in the state of a guardian manager. Then partition of HUF. So partition can be either full partition or partial partition. There is a misunderstanding that partial partition cannot be done. It can definitely be done. It is just that partial partition is not recognized in the Income Tax Act. So how does it matter? I'll give you an example. I have two houses. My HUF has two houses. I give one house to one of my son. You take, you live apart. Now my son has taken that house and he is living apart. So there is a partial partition of that property. One house is still there in HUF in which we all live together. I have just given one house to my son. Now this is a partial partition. Now if my son earns any income, if he lives in this house, there is no income, so no issues. If he gives that house on rent, then it will be assumed that no partition has taken place, and the rent from that house will be clubbed in the hands of my HUF. So partial partition, the result is that they'll assume no partition will happen and the income will be clubbed in the hands of HUF. So this can be effectively planned. And partial partition can be qua members or qua property. If we are 10 members, we can separate 5 members, and remaining 5 members can continue in the HUF. We have 10 properties, we can give away 9 properties to everybody, and 1 property we can keep in HUF. So this can be done, no issues. Partition can be oral, arbitral, suit can be filed, it can be through a deed of partition anyways. Then on every death, how will the share will realign? So on every death, there is a notional partition to align the share of co-partners, right? So for example, there is a 1/10 share. If there are 10 members in the family, everybody has 1/10 share. Now the deceased will give his 1/10 share to another person, so that other person will have 2/10 share after that. All others will continue to have 1/10 share, but the deceased has given his 1/10 share to his wife, so his wife will have another 1/10, so 2/10 share. So this is the case of notional partition held in the case of this concept is formulated in the case of M. Arumugam Supreme Court decision. Then, as we have discussed, HUF will contain of karta, co-partner and member. Now, very important to understand how will the HUF fall. So, a person who is forming an HUF, his wife and downstream his children or children of children, they will constitute an HUF. So, it is not, it is always downstream. Now, very important concept which we need to know. If a person receives something from HUF, my HUF gives me 10 lakh rupees. I am karta of the HUF, or say my father is a karta of HUF, and I receive 1 crore rupees from my HUF. Whether it is taxable? No. Vineet Kumar Raghavji by Bhalodia's decision, it is said that when you receive something from relative, it is not taxable. And what is HUF? HUF is a gift, group of relative. So when it is a group of relative, you receive from a group of relative, it is as good as receiving something from a relative, and it is not taxable. On the other hand, if HUF receives something, what will happen in that case? So when HUF is receiving something, you need to see who is relative for HUF. So if you see the definition, relative is defined to be a member of the HUF. So a member of co-partner will be the relative of HUF. Now, in this case, let's take an example. If I give, if I have an HUF, I give 1 crore rupees to my mother. My HUF gives 1 crore rupees to my mother. Whether it is exempt? Yes, it is exempt, because my mother is receiving from a group of relatives. So who are the group of relatives? It is her son. So she is receiving from her son indirectly. So it is not taxable. But now consider the converse case. My mother is giving 1 crore rupees to my HUF. So whether it is taxable, so you need to see my HUF. Who are the relatives, members and co-partners? Is my wife member? Yes. Is my children co-partner? Yes. Is my mother a member? No. Mother is not a member of the Karta's HUF. So this held in the case of Subodh Kumar Gupta, where the HUF received something from the mother of the Karta, the amount was held to be taxable in the hands of HUF. Then, what is an ancestral property? When in Mitakshara Tika, it used to say that when the property is received through 3 generations of the male lineage, father, grandfather, great grandfather, it used to take the character of ancestral property. But it was deemed to be HUF property. But now things have changed after the codification of Hindu Succession Act 1956. The concept has gone. Now the property which we ourselves voluntarily throw into HUF will only be an ancestral property. Otherwise, the concept of ancestral property has gone. Ancestral property earlier could not be delineated. They used to pass from generation to generation. But now if you see the decisions of Yudhishthir versus Ashok Kumar or Ashnur Singh, it is clearly held there is nothing like ancestral property unless you yourself give it in the HUF. Suppose, for example, a property you receive from your great grandfather, you will receive either through will or intestate succession or partition. It will be in your individual capacity as you receive. It will not become your HUF property. Why? Because now Hindu Succession Act does not deal with the concept of ancestral property. This is a very important concept to be kept in mind. There was a myth going on that ancestral property is there, you cannot give it away. But now the concept of ancestral property is almost finished. Joint holder and nomination. This is very important concept. See, this is very important even from movable perspective. We have 2 depositories right now, CDSL and NSDL. Now, when a person dies, if there is a joint holder, all the shares, we need to write an application for transferring of those shares in the favor of joint holders or the nominees. But a joint holder or nominee is just a stopgap arrangement. They do not become owners of the property. Will or Indian Succession Act will always prevail over the joint holdership or succession of the property. You see, these are only the stopgap arrangement. Nomination is just to ensure smooth transition. Normally, what is advisable to do when we plan a will, if you want to give XYZ shares to Mr. A, then make the norm in case of those XYZ shares, register Mr. A as a nominee so that Mr. A gets it and he's the real owner. So there is a smooth transition. So you need to avoid the conflict between nomination and will, because ultimately it will be the will which will prevail, but immediately the property will be received by the nominees. So nomination, joint holder is a must. Otherwise, even in case of transition of shares, dematerialized shares through the depositories brokerage, you face huge problems. If there is no nomination, then they have categorized it 5 lakhs or more than 5 lakhs or less than 5 lakhs. If there is no nomination, then you need to get the will probated from the High Court, which is again a big headache. So it is always advisable that do nominations, alert nomination, and nomination should be synchronized with the beneficiary regarded in the will. That is the best case and best circumstance. Now, a question arises, section 72 of Companies Act deals with the case where it says that property will vest, shares will vest in the nominee. But again, it is the stopgap arrangement. Bombay High Court in case of Shakti Yazdani has clearly held that ultimately it is the Succession Act will prevail. It is the person who has been regarded as the beneficiary or intestate succession that will prevail over the nomination. Nomination is just a stopgap arrangement. So to ensure a proper succession of business, nomination and joint holder are very good tools. It will also help you in registration of legal heir and income tax. So practical advice. Then what is the hierarchy? First, joint holder, they'll get everything. If none of the joint holder is alive, then all the property will vest in the hands of the nominees. But ultimately, either joint or nominee, everything needs to be synced with the will. which is your intention of whom you want to give the property. Now, we will come to the private trust. Should we take some queries before we dwell into private trust, because this would be altogether different topics, sir.
Sure. I have compiled some questions that has came up till now. Will you be seeing the question box, or shall I share my screen and we'll take up the questions now? Sir?
You can share the screen and I'll
Yeah,
take
I'll share my screen. 1 minute. So this is compiled from the starting. So I hope my screen is visible, sir.
Yes, it is visible. Right. Under Mohammedan laws, will are not recognized if a person has no male issues and only daughters. On the death of the person, 2/3 of the property goes to daughters, 1/6 of surviving spouse, and balance to brothers and sisters of the deceased. How to tackle this kind of situation? Sir, unless the Uniform Civil Code is there, this is a Shariat law, which is already there. So under Mohammedan laws, 1/3 property you can give it to the 1/3 property you can still bequeath to whomsoever you want. Now, how do you want to tackle this situation? I am not getting the problem in this situation. You have described the law correctly that 2/3 will go to the daughters, surviving to so and so, and balance to brothers. But how? What do you want? What kind of solution do you want? Is a different thing. Through will, you can give 1/3 property to whomsoever you want. Remaining, the issue will be there. Now, for the remaining property, it is better that you distribute the property in your life itself. Don't wait for the succession. The only solution to this problem appears that you give the properties during your lifetime to your whomsoever you want. That could be one issue. In case of a Muslim has married under Special Marriage Act, the will made by Muslim is regulated by Indian Succession Act and not Muslim personal law. Frankly speaking, I need to revisit this issue, and you can mail it to me and I'll confirm you or the, because Shariat law is a bit more complicated and I have limited understanding of that. So I can reply to you it later by way of email. Third query is inherited properties in case of intestate death does not have share, only children have share. Inherited property in case of intestate death, husband does not have a share, only children have share. No, it is not like that. See, inherited property, if there are children, then husband, son and daughter all will have equal share. It is only a situation when there are no children, then you need to see whether the property has come from her father, she has inherited from her father, or from her husband's side. If it is inherited from her father's side and she does not have children, then it will go back to her father. But in this case, her husband and her children, everybody will have a share in case of intestate succession. Private trust created before 1920 and only male successors are only members of the trust. Is it possible now, after 2005, female successors are also members of trust without making any change in the trust? See, trust is not governed by Indian Succession Act. Indian Succession Act and Hindu Succession Act have been amended. Trust is governed by Indian Trust Act and Indian Contract Act. So the right of daughters will not automatically come. It is the charter of the trust, what the trust deed says, that is important. Unless the trustees, with the consent of all the beneficiaries, incorporate the right of female successors, I doubt the female successors will get the right in the trust. Then, please example probate with please explain example probate with an example. What exactly needs to be done? See, you need to take your will to the High Court and you need to file an application through a lawyer for sanctioning of that will. The court will call for objections from all the parties or relatives. You need to give a public notice through a newspaper. If any objections come to court, fine. If court, after giving reasonable time, maybe 3 months, there is no objection to the will, then court will approve the will as sanctified. Court will go through the will. Court may call the witnesses. Okay, please confirm that you have seen the person signing this will. If the witnesses confirm, yes, we have physically seen him signing the will, then the court, after taking cognizance of all the circumstances, will give a seal on the will and pass an order that this will is probated. So that will then become final. Can a will contain both self-acquired and joint family properties to be distributed among beneficiaries? Sir, first of all, is it a joint property under HUF or not? Because now the concept of ancestral property has gone. So whatever right you have in your capacity, you can give. You have a right in your HUF, that right, your share in HUF, you can give it to somebody, no issues. But if there is a joint right in not separated right, for example, if your HUF has 5 houses and you do not have any identified share in any house, so you cannot give, I have a share in this house, I give it to so and so. You can give your share in your HUF to somebody. So there is nothing like ancestral property or joint property. It is only HUF property, and in HUF you can give what you have. You have a 1/10, or if you are 10 members, you have 1/10 share that you can give. You cannot, apart from that, self-acquired property, you can give everything. And HUF share you can distribute. Can a beneficiary be executor of a will? Definitely, beneficiary should be an executor of the will. It is always advisable, because otherwise to get probate, it would be difficult that some third person who is not getting anything may not be interested in getting it probated. So it is advisable, and it is very common to make spouses who are the ultimate beneficiaries as executors of the will. If in the will there is only one beneficiary, whether executor is required, executor is always required, because for filing return, for doing anything, executor is required. If there is no executor, maybe you may face a legal problem to from the CDS and depositories or various institutions. So it is the executor should be there, because return will be filed by executor. Everything has to be done by executor. If there is no executor, they can ask you to get an executor appointed from the court. So even if there is only one beneficiary, please write the name of executor. If Uniform Civil Code comes into existence, will it take over Hindu Succession Act, thereby removing all the complications? I think the law minister would be the better person to answer this. But definitely, if we all would not be required to know all the different laws, there will be one common law applicable to all the persons that would bring in simplicity, which is a rare virtue now. If in a partnership deed, if a clause, this partnership is terminable at will, retirement or death will not dissolve the firm. In case of death of the partner, any one of the legal heir of such partnership be taken as partner, contains whether this is holding as a continuing firm. One important aspect which I would like to highlight apart from your question, if you write if the partnership, this partnership is at will, this should be avoided, because at will, if there are 10 partners and one partner give you notice to dissolve, you will have to dissolve. So it should always be written, this is the duration is at will of majority or will of all the partners. If you have written it that in case of death, any of the legal heir shall be taken, then you are giving discretion to other partners. So any of the legal heir as designated by the partner in his will shall be taken as a partner. If you write that, that would be a proper succession clause in the will. What is the meaning of exception to section 69? Section 69 says marriage revokes a will. So exception is that this will not be applicable in case of Hindus and Muslims. So if in case of a Hindu male has made a will and he gets married, and after marriage he dies, his will would not get become invalid or void just because it was made before marriage. But it is always advisable to revise the will after marriage. If it is a case of a Christian or another religion following, then in case section 69 will automatically revoke a will. It will be assumed that there is no legal will, and then you will have to go as per Indian Succession Act. That has to be done. In case a partner writes a will to substitute a relative as a partner, in a case where partner writes a will to substitute as a, see, ultimately partnership is not governed by Indian Succession Act. Partnership is what? It is a contract between the partners. So whatever one person may write will not be binding on the other partners. And Partnership Act says that unless a clause is there in the partnership deed itself, it will be required the permission of all the partners to admit a new partner. can you throw more light on need for registration of will? See, registration of will gives more authentication of will because it is signed before a registrar, sub-registrar. It becomes a public document. So presumption, it raises higher presumption that this will is genuine. This will be when you want to transfer some property. You have received a property and now you want to sell a property. So unless it is a registered will, it is difficult to get the property first in your name and then to transfer it. And the person who is purchasing the property will require a copy of chain documents. So registered will form a better chain document and you will have a better title over the document. Otherwise, your property may be disputed or you may not fetch a good value for that. Now, in case of where a partner writes a will to substitute as on death, whether capital gain levy on transfer, no, capital gain cannot be levied when a property is transmitted through will. What if a person is not identifying to a particular religion? How will it affect the making? See, if I am not identifying myself as a Hindu, I will be covered under Indian Succession Act. So then the benefits or privileges which are given to Hindus or Muslims or such religions will not prevail, and I will be governed under Indian Succession Act. Can testator write separate will for each beneficiary or property wise so that the beneficiaries are made aware what is bequeathed to her or him? See, if you do so, in every will you need to write, I have so many properties, and regarding other properties, I have written a separate will, so that prevails. So ultimately, when the last will prevails, the last will have clause that earlier wills are made regarding other properties, and they are still valid. So they will be incorporated in your last will. It is always advisable to have one will for one property for all the properties. Separate will making may create disputes and litigation. What is a gift in contemplation to death? See, when a person is dying, maybe there may be situations a person who is expecting is under cancer or some this kind of disease. So there he may make a gift. I am going to die, so I want to gift so and so to you. Further, you can write me on mail. I will elucidate this concept in detail to you over the mail. In case of deceased person, how the adopted child is considered? That is, child before the child attains majority. See, in case of a deceased person, then the child will be the beneficiary if he's in, but there will be a guardian to the child. Court may appoint a legal guardian. Probate of will depends of the location of the property or residential. See, it depends on the location of the property because there are two things. If you are a resident of Chennai, for example, so you are under Madras High Court, so your property may be situated anywhere, it needs to be probated because it is your situs. If you are a resident of Delhi, but you have property in Madras, for that limited Madras property, Chennai property, you will have to get it probated. So it is like that. If few properties out of many are located in specified cities, it depends. See, if you are located in Chennai, your property is in Delhi. So Delhi person register, when you transfer it, they may not ask for the copy of probate from you. But if the property is in Chennai, the sub-registrar before transferring the property would ask for probate details from you. How the property of deceased Hindu person who died intestate leaving behind 2 wives and children born to both wives. See, it is the definition a class 1 legal heir. So both the wives will be class 1 legal heir. All the children will be class 1 legal heir. So you will have to divide the shares equally in case of everyone. If the person dies interstate, return up to the date of death will be filed in his name by the legal representative. Absolutely right. What about income from the date of death till the estate is distributed? If it takes 1 or 2 years to distribute the estate, and there are 4 legal heirs by whom the return will be filed. See, whosoever is getting the income, it is basically taxed in the hands of tenants in common. So whomsoever, in case of interstate death, there will be a administrator appointed to manage such wealth. So that administrator will be obliged to file the return, but it will be in the capacity of tenants in common. A separate PAN number will be there. estate of Mr. So and so, late Mr. So and so, and tenants in common would be the capacity, and then return will be filed. The return will be filed in what capacity? Whether it is to be filed in the name of estate with a new pen, yes. In the name of estate with a new pen, it has to be taken. Under the present system of filing tax return online in the income tax portal, there is no provision for any attachment to claim total partition. As per section 171, there is also no provision in tax form for such claim. How to make? You write a letter to the income tax department. It is their mistake. So whenever there is a complete partition, you write a letter to your jurisdictional assessing officer and get it inverted. That would suffice. So right, I think
those
we
were
are
the
finished.
questions, and we have some more questions that came up, sir, but we have presentation to complete, right, sir? And after that, can we take, or how do you want to go about it, sir?
Very well. So I'll start with the presentation now
Yes,
on
sir.
private trust.
So how long will it take for this presentation to complete, just for the compiling the questions?
You may guide how much time I have. So accordingly, I'll
As of
deal
now,
with
we have
this.
close to 40 minutes left out, sir. 8:20 as of now. We have scheduled this meeting till 9 o'clock. So
Okay.
till then, you can complete the finish 40 minutes extra of the time. We can finish up. If not, we'll as per your call.
Up to 9 we will go, sir. If at all some questions are left out, you can answer if possible through mail.
Okay. Very well, sir. Thank you.
Thank you.
Now we are dealing with a instrument which is called private trust. Now this is a very interesting instrument. Why there is a need of private trust? I'll share an example, a story with you. There is a family, a husband, wife, they have a child. Husband and wife, they both have a good control over the business. They both are into business. They own a company in which they both have 50% share. So they have established a business company. They have 50% shareholding. They have a child. The husband and wife do not have much faith in each other, but they want that the benefits should go to their child. But the husband apprehends that if I transfer some of the shares to my child, my wife may take it from them or exercise her control, and she may become the owner of the company. The wife may also think that the husband may do so. So how to devise some plan for this? So one way to do this is that make a company. They make a company. They may issue two classes of equity share. One equity share with voting rights, and they both hold 50%, and another equity share without voting rights, through which this is a separate class of shares without voting rights, and dividend will go to their child. So this is firstly restructuring through shareholding pattern. Another way is then they can make a private trust. They can settle their shares in that private trust. They both can become a trustee in that trust, so that they both will have control over the private trust, and their son will become the beneficiary of the trust, so that any income which arises to the private trust will go to the benefit of their son, who is the beneficiary, so that he can enjoy. Another example, there may be a family where they have a child which is specially abled child. Now the parents worry about the future of that specially abled child. What they can do, they can make a private trust. They can settle a corpus in that private trust, and they can appoint themselves till their life, and after their life, their confidants or their somebody on whom they have faith, or even professional trustees as the trustee of the trust, and the specially able child can be the beneficiary, so that for the life of the specially able child, the maintenance of that child is ensured, and the corpus may not get wiped out or may be misutilized, or they may not be cheated. So this is again another example of private trust. So private trust has multiple uses. As you can see, the journey of private trust in India. Till 1980s, there were Tata Trust, Shapurji Palundi Trust. 1980s to 2000 was the adverse time for trust because the taxation regime was very unpopular. Now, with the rumors of return of the estate duty, the trust concept has again gained its significance. Inheritance proposal was already there in budget 2013, but then it did not see the light of the day. Asset protection trust, many times what happens, people would like to who are venturing into business, many industrialists have to give personal guarantees, so they don't want their personal asset should go, so they settle their personal asset, a part of their personal asset, in a private trust, so that even if they in future they get bankrupt, their family does not have the problem of survival. Another issue, divorce cases. Many cases it is seen that in case of divorces, the wife or the divorce partner takes almost 50% of the wealth. So people may plan a private trust so that they may irrevocably settle a great fortune to a private trust of theirs, with the beneficiaries under their control. But if the private trust is settled, a discretionary, irrevocable private trust is there. So even after divorce, the husband has a limited means from which the wife or the spouse can take a limited part, but not the full fortunes. We have seen in many cases, Jeff Bezos, Amazon's case, that almost 50% of the wealth has gone to his wife in case of divorce cases, or it may be the other way around also. So asset protection, insolvency, divorce cases, in all these cases also this private trust can be useful. Before dealing or starting with this topic, one thing I would like to start is that private trust, okay, for minors it can be a tax planning device, but for other cases this is an instrument to serve many other purposes, and it should not be seen as a tax planning device, because in the present regime, tax planning is very limited through this private trust, and one should not advent into these field, but it can be used for serve various purposes which are there. Now, let us understand the structure of the trust. A settlor, a person who is the owner, who has some fortune, who wants to give it, can make a trust deed and transfer the property to the trust. Now, how it is done? Practically, I will tell you, a trust deed is made where with rupees 500 or 5,000 as initial corpus to save stamp duty impact. You make a trust with a small amount, and thereafter you give a check in the name of bank account of the trust and transfer 1 crore, 5 crore, anything. So you will save stamp duty in that case. So settler would eventually settle rupees 5 crore in a private trust. He will make some trustees. These trustees will manage the property of the trust. Once settlor gives the property into the trust. Now there can be two types of transfer: revocable, irrevocable. If it is given irrevocably by the settlor, then the settlor will have no right over the property. Then it will be the trustees who will manage the property, who will hold the legal title over the property. So basically, trust is what? Trust is basically a collective management. The legal title will be with the trustees to hold and manage the property. Why trust? For the benefit of beneficiaries. The person for whom we want the benefit should be there, will be the beneficiaries. And last part is assets, which will be held by the trust. So this is the structure of trust. Now, can a trust have a common person as all the three? Settlor, trustee, beneficiary? No. The thumb rule is 2 out of 3. A person can be either settlor, trustee with some third beneficiary, or settlor can be some different, trustee and beneficiary could be same, or settlor or beneficiary could be same, the trustee can be different. So it depends on all different kind of permutation combinations, and there are some implications also of these things which I'll be discussing. There is another concept of protector. Why the concept of protector? I once met a person who said my grandfather had made a private trust and he has settled 35 lakh rupees as a corpus of the trust. So I was amazed. I said, oh my God, you must be now a big billionaire. Bole, no. Why? Bole, the trustees charge so much fees and manage the assets in such a way that I have only got 80,000 rupees on maturity. So this gives us the importance of the protector, that there must be one person who used to look whether the trustees are doing everything properly or not. So there can be one protector who can lay down or who can monitor the action of trustees, because nowadays the concept of professional trusteeship is coming. You can appoint any ICICI Bank or Kotak Bank Financial Services as a professional trustee. So a settlor is a person who wants his disabled child to be maintained. So he may make a private trust and give the management of that investments to a professional company, and the dividends can be given to the beneficiary son. But then whether after his death that professional trustees are dealing with it properly or not, so they can appoint a protector. One member of my family, so and so, or my uncle's family will act as a protector to monitor this trust or not. So this protector concept is also there. Then many I have made a set. I am a settlor. I have made a trust for my son. Now after 15 years, my son is also earning income. He says, "Father, you have made a wonderful trust. I would also like to invest in that trust. I would also like to contribute in that trust so that proper wealth is created. Ultimately, it is for my benefit." So in that case, if a person who is not a settlor and he is contributing to a trust, he will be known as a donor, contributor, or transferor. What happens in this kind of trust? When a person is, for example, the son who is a beneficiary, if he himself is contributing to the trust for his own benefit, the trust was irrevocable. But since I am contributing for my own benefit, the trust will be deemed as revocable. So it will be deemed a revocable trust, and whenever it is a deemed revocable trust, the income pertaining to that wealth which is contributed by me for my own benefit will be clubbed in my hands. So whenever the trust is a deemed revocable trust, if it is I am contributing, I am settling for my own benefit, then it is a deemed revocable trust. Then section 60 to 64 of Income Tax Act will come into play, and ultimately if trust earns 1 lakh rupees on the income on the corpus which I have contributed for my own benefit, then that 1 lakh rupees will not be taxable in the hands of the trust. It will be taxed in my hands through the provisions of clubbing of income. So this is an important concept. Now, trust deed, what should it have? So all the basic information regarding settlor, trustee, beneficiary, who will be the trustees, how will be the trustees appointed, who will be the beneficiaries, what will be the life of the trust, because the trust, because of rule of perpetuity, cannot have an unlimited life. So life of the trust, arbitration mechanism, how to amend the trust deed, all that should be there in the trust. Now, what are the types of trust? This is very important because this will govern the taxability of the trust. Specific trust. I have made a trust for my 2 children, and I say both my children will have equal share. So that is a specific trust where the beneficiaries are identified. Another trust is a discretionary trust where I have 2 beneficiaries, my children, but what share is given to which child I am giving at the discretion of the trustees, or whether my children will get anything or not, everything is at the discretion of trustees. In that case, it is a discretionary trust. So it is said that in a discretionary trust, a person has nothing but a hope. There is no right. So when we hear about estate duty, people make discretionary trust. So that a person in his life, he has settled his wealth to the discretionary trust. So after his death, the children have not got anything. If it is a specific trust, it will be, the law will say that okay, the child are deemed to got so and so amount, equal amount. So that will be specific trust. But then a discretionary trust, uh, we have no right. We just have a hope. So the property has not transferred from one generation to another. So in that case, it is called a discretionary trust, and it may be used. It is used in the abroad countries to save the estate duty. Another issue is irrevocable trust. Irrevocable trust is important when you want to protect your asset, because if you have given a personal guarantee and before that, if you have irrevocably transferred, see, if you have a revocable transfer matlab it can come back, means it can come back to you. So if it is a revocable transfer, the creditors can recover from that property in the trust. The estate duty will be applicable, insolvency code, divorce claims, everything can be claimed from that trust. So irrevocable trust is there, a trust where I contribute without a right of receiving back. But then 90% of the trusts are irrevocable. But when it is for my own benefit, then it can be held as a deemed revocable trust when I am defined as a beneficiary. So deemed revocable, it is taken in my hands. And another last category is a testamentary trust. Testamentary trust is a trust made through will. So if I make a trust through will, there are advantages of tax rate into it. Otherwise, in discretionary trust, maximum marginal rate may be levied. Now, then there are some other type of trust which are not common in India, generation skipping trust. If I give it to my child in abroad, there is a estate duty. If I give it to my child, 25% is reduced, 75% is remaining. Then if my child gives this to his child, so then out of 75%, more 25% is reduced, and then he gets something around 55%. So to avoid this, I directly give it to my grandson through a trust. So that saves 25%. So then this type of trust is there for 37 years. Then a grantor trust. A grantor trust is a settlor trust who makes this for himself for his own benefit. Dynasty trust to avoid estate duty. I park my major corpus or wealth in a trust so that nobody in my generation would be able to sell it, but they will be only able to enjoy the benefits of it. Asset protection trust, discretionary trust to avoid insolvency, creditors, divorce claims, living trust. Now, what happens like in Chennai, the probate is still easier. California, it is very difficult to get a probate. So, a person, what he does, he settles all the property in a trust and says that after my death, this property will go to so and so beneficiaries. So the property is transferred, and in case of distribution of properties from a trust, no will or probate is required. So to avoid the probate, a living trust is made in California. Then we normally see provident fund trust. All these are type of crummy trust. Basically, life insurance, LIC, SIP, all these are done by this crummy trust. So these are different types of private trust which are used. Then provisions. Let us understand the provisions which are applicable. See, I'll in simple extent explain you the provisions in case of specific trust. Specific trust, the income of the trust is taxable in the hands of beneficiaries in the like manner or same extent as the beneficiary. I'll again repeat. Normally, the income of the trust is taxable in the hands of the trustees in capacity of trustee. So I have made my son one trust. So I have made a trust for my son. Now trustees of the son trust will pay the tax normally on the, but how will the tax be calculated? So they will see the tax which would have there if my son would have directly earned that income. If my son has no taxable income, and if he has earned 1 lakh rupees, which is still below tax, so no tax, so trust will also pay no tax. If my son has 5 lakh rupees income and I receive more 1 lakh, so 20% tax on it is 20,000. So 20,000 will be the tax in the hands of trust. So now what is being done in case of specific trust? specific trust or determinate trust where the shares are defined, what is being done, that the beneficiaries offer the income their own hands. So that trust may file nil return because the income is already taxed. So the act gives an option to tax it either in the hands of the trustees at the rate or in the like, exactly in the same manner in the case of beneficiary. So tax will be same, either the trustees paid or the beneficiaries paid. So why not to pay directly by the beneficiaries, so that the return of trust can be filed in an easier manner. So this is a better provision. Normally it is done. On the contrary, in case of a discretionary trust, now you don't know what is to be received by which beneficiary. So the trustees pay the tax at the maximum marginal rate. So in case of trustees, it is maximum marginal rate. In case of a specific trust, it is in the like manner and same extent as the beneficiary. Now, specific trust, discretionary trust. There are these two type of trust. Specific trust, discretionary. Specific in the ratio of the beneficiary. Discretionary in the end of trustees is maximum marginal rate. Now, when the specific trust is doing a business, then it will also pay tax at the maximum marginal rate. So whether specific or discretionary, if it is doing business, it will pay tax on the maximum marginal rate. Now, if the tax is paid by the trustees in the representative capacity, they can recover it from the trust. There is one more important concept, be it a specific trust or discretionary trust, if it is a revocable transfer, for example, deemed revocable trust, then the income will be taxed in the hands of the person, contributor or donor, because there will be clubbing of income. If the contributor donor is also a beneficiary, then there will be a clubbing of income, even though it may be a direct or indirect trust. Now, another issue, some small issues in this is that specific trust, trustees will pay the tax in the like manner and same extent as the beneficiary. Discretionary trust, it will be taxed in the hands of the trustees. See, in this case, you can see there are 4 beneficiaries. So everybody would get 25% share. So you compute the tax of these 3. ABC, the income is exempt. So A pays tax of 10, B 10, C 10, and this 0. So total tax which has to be paid by the trust is 30. Either it is paid by the trust or they pay it individually. That is fine. So this is the one way. Now another rule, let's understand, if there is a specific trust, if it does not carry business, then like manner same extent as the beneficiary. If it carry business, then maximum marginal rate. But if it is a specific trust made through a will, which is called a testamentary trust, and even if it carries business, it will be taxed in the like manner and same extent as the beneficiary, right? So I hope this is clear. Specific trust, like manner, same extent, except business. Business you need to see if it is through will, then still like manner, same extent. Not through will, then maximum marginal rate. And presently maximum marginal rate is around 42.74%. Then there are decisions that like manner, same extent means there will be as many assessment on the beneficiaries, trustees. For example, if there is a XYZ trust and there are 5 beneficiaries, so there will be 5 assessment and 5 returns of income in case of that trust. 5 assessment, 5 return may be filed even 1, but there will be 5 different assessments as far as 5 beneficiaries are concerned. Then what will be the status of that trust? So it will be borrowed from the beneficiaries. If the trust is 1 individual and 1 HUF, so the tax rate will be computed in accordingly. If there are all individual, the trust will be individual. If there are 1 individual, 1 company, 1 charitable, 1 company, so it will then be treated as an AOP as a whole while registration. Discretionary trust, the beneficiaries only have a right to hope. See, in this case, beneficiary will be totally on the mercy of the trustees. So trustees will decide whether to give or not, how much to give to which person. So discretionary trust, they tax it at maximum marginal rate always. But there is one exception. If normally why it is done at maximum marginal rate, because we don't know how much to give to whom. But if we have distributed, suppose trust at 5 lakh rupees income, so out of 5 lakh, 2 lakhs is already distributed 1 lakh to both the persons. So that amount which is already distributed may be taxed in the hands of beneficiary, and remaining 3 lakh which is not distributed will be taxed at maximum marginal rate. Remaining 1 lakh which is distributed to both will be taxed in the hands of beneficiary, and it will not again be taxed in the hands of the trust. Discretionary trust, MMR, there is again an exception if it is a PF, Provident Fund Trust, or Gratuity Trust, or it is through a will, or if it has beneficiaries and none of the beneficiary has any income which is exceeding the taxable limit. So then in that case it will have enjoy the slab rate. Otherwise maximum marginal rate 42.74%. Some important principles: if there is a long-term capital gain, so then maximum marginal rate will be 20% plus surcharge plus cess. In that case, it will not become 42.74%. Then, if the amount is already taxed in the hands of beneficiaries in case of specific or discretionary trust, can it again be taxed in the hands of the trust? No. Delhi High Court in case of David Joseph has held that once it is taxed in the hands of beneficiary, it cannot be, and it should not be again taxed in the hands of trust or vice versa. Assessment can be made either on the trust or beneficiary, either of the persons. Then filing of return, ITR 5, if it is the sub status, if there is a different status, then there are some problems which are coming in the case of filing of return. Earlier CBDT has also issued a circular for manual filing of return. In that case, either you change the trust deed or make some alterations. Deemed revocable trust, we have already discussed 61 to 64. If my father has made a trust for me and I am also contributing to that trust, so any income which is arising in the hands of trust which pertaining to amount which I have contributed will be not be taxed in the hands of firm, but it will be clubbed in my hands. That is the concept of deemed revocable and revocable trust. Then testamentary trust, we have already discussed. If a trust is made through a will, and that is the only trust made through that will for those beneficiaries, then you will enjoy the benefit of tax slabs in that case. If all beneficiaries are individual, the trust will be individual. If there are different beneficiaries, so then the status of trustees may be relevant. See, because income, this trust concept is a very different concept, and our act provides a limited guidance, and it is always all maximum through judge-made jurisprudence on this topic. Status of discretionary trust with individual, it will be taxed as a individual trust, and you will get the benefit of 54 and others, 54F, 54, all the benefits will be eligible. And when there is a trust where there is an interlocking and you cannot determine any beneficiary and nobody is claimant, then as cheat article it will go to the, all the property will go to the government of India. There may be issues where they make it so complicated that you cannot determine who is the beneficiary and for whom the trust is made, and there is no claimant. So in those cases, it all goes to the government ultimately. Example of trust structures. This is a classical structure. A settlor makes for a trust. There are beneficiaries, trustees, and assets. So this is the classical trust. Another trust which see, US has a FATCA law, Foreign Account Tax Compliance Act. So an industrialist who has some non-resident children, so he wants to give the benefit to them. He wants to make a trust, so he will make a discretionary trust. How? See, what he will do, all the assets, operating company, investments, other assets will be placed under one master trust. That master trust will have two trusts, Son 1 trust, Son 2 trust, and this will be a specific trust. So master trust, any income which arises will go to Son 1 trust and Son 2 trust equally. Son 1 trust and Son 2 trust will be discretionary trust with Son 1 family and Son 2 family as a discretionary beneficiary, so that whenever they want they can withdraw it. Otherwise, if it is a specific trust, the income will be taxed in the US or other countries where they are resident. So if it is this second stage, if it is a discretionary trust, so then there is no FATCA Act or the taxability of income in those cases. So this kind of structures can be planned. You can even make multiple master trusts. For example, I am having an industrial is having a textile industry, a cement industry, a paper industry. So I can make 3 trusts, and I want my children to enjoy the benefit of all the trusts. So these 3 trusts will have 3 parent trusts, and they will have share in all the all my children will have shares in all the trusts. So this kind of planning also can be done. So parent trust and son trust, this kind of trust can be made 3 stages. So this kind of plannings are done in case of big industry houses who may have children abroad or who may want to avoid estate duty. So this kind at this layer, they have already set up discretionary trust. Migration of trust to the asset to this trust. So there may be various implications like now section 56 is there. So unless you make a trust for your relative, the income will be taxable in the hands of the trust. So those kind of migration strategies are there. You gift the asset, you sell the asset to the trust, family arrangement, settlement, primary infusion, merger, demerger, all these kind of issues are there. So all these statutory laws need to keep in mind while you are dealing with the trust. Professional trustees, as I said, bank, financial institution, administration fees is there. These are some examples of basically professional trustees which are already there, some Indian, some abroad. These kind of agencies are there. So in this kind of there, you need to make one protector who will keep a vigilance on the trustees, and the trustees will deal with the property as per the trust law. It would be like a portfolio management services, and advisory board can also be there who may guide to the trustees from time to time whether to take what decision or not. So this kind of structures can also be made. Need for professional trustees. There are various reasons, family reason, technical burdens. You may not be competent to manage the investment. So this kind of decisions can be taken. A trust should have a flexible structure for modifications in future. Otherwise, the property may get entangled in the trust. It is advisable to set up with, in case of children who have special needs or individual who have wealth more than 5 crore rupees or family disputes. There are different costings, like for example, big fours have been charging rupees 5 lakh for establishment cost, AMC annual maintenance 2 to 5% per annum of the property is also being charged. So these are some examples. Stamp duty, as I already advised, you need to settle it with the initial amount of 5,000 and then transfer the property or amount. So immovable property, there has to be registration, so stamp duty will be there. For movable property, there won't be any stamp duty on subsequent transfers. Jurisprudence: a trust for unborn child is a valid trust, but then it has to be only for the unborn child. Otherwise, he will not get the specified interest in those cases. Then there may be cases where the beneficiary may die, but settler may remain alive. So section 77 of the Trust Act says that when the beneficiaries die before the settlor, then the property will come back to the settlor in such specific circumstances. How will the trust finish? The trust may finish when the objective is fulfilled, because the trust cannot be for unlimited period. There is a rule of perpetuity that the last living descendant who was the beneficiary, the trust is valid till his life. When the last living descendant is no more, the property will have to be distributed or dissolved in the case of trust. Against a trust cannot be made for accumulation, it has to be for benefit and distribution of the children. So Transfer of Property Act is also relevant here. It prohibits a trust which is made only for accumulation purposes. Minor children tax planning. You can make separate specific trust for every minor child. See, for HNIs who are in the higher tax slab, they can make a trust for their minor child. They can contribute a corpus for their minor child. It will be a specific trust, but you can mention that the minor child, until he becomes a major, he may not be able to use that amount. So if you make this will be treated as a separate entity, separate file, which will get the slab benefits and all the benefits. So clubbing will not be done. Otherwise, if there is any income in the hands of minor, it would have been taxed in the hands of parents. But as held in Supreme Court, in case of M.R. Doshi, minor children, a specific trust for minor children will be treated as a separate entity, and there won't be any clubbing provision. So this was all I felt was important with regard to private trust. In the end of the presentation, I would like to acknowledge to my father and my gurus from whom all this I have learned, Mr. Yogesh Tharet, Bansi Mehta, Mr. Anup Shah, Dr. Girish Ahuja, and all other seniors, because of whom I have been able to gather the knowledge on this complicated topic. Thank you very much for such a patient hearing. It was really very meaningful interaction and my first debut lecture at SIRC. So thank you, team SIRC. My contact details are available here. So you can write to me or contact me in case of any queries are there. Thank you very much for listening. Thank you.
Stop sharing the screen, sir. Almost time. So can we take 1 or 2 questions, or else can we mail it to?
How many questions are there, Silva?
So you have something around 15 to 20 questions more
It
than
will be a
that.
good number of questions, because I think a great job done by you, Pankaj, because I think the topic is very wide. So you had to be quick. I could understand that. So there should be definitely very good number of questions. If you don't
So
mind, I think it.
So can we take till we have? Can we take 4 or 5 questions, or else we'll close this one? We'll mail it to the side.
Mail and whenever he finds time, let him answer.
Yes, he can respond it, sir. Thank you, sir. Up to you, sir.
Is that okay, sir?
As you feel, sir.
Yeah, because
Yes.
it's almost 9 now. It should be dinner time for all. Because of some other programs of SIRC, we have made it 6 to 9 for 4-5 days. Otherwise, it was 5 to 8. So when 5 to 8 was there, we pulled on up to 8:15, 8:20 like that. But it's already 9. Anyway, we'll not be able to finish all the questions. So let it be all questions be done through mail answering. So thank you very much for the great job done by you on behalf of SIRC. Being a maiden program at SIRC, we are very happy that we added one more erudite speaker for our team or for our list. Thank you very much for accepting our invitation and making this possible. And you are the people who have the passion to share your knowledge. That makes ICAI very proud. That is where we keep speaking that institution is above individuals. So because you value the institution more than individuals, so you have come here to strengthen the institute and all the members. So thank you very much from SIRC.
Thank you, sir. Thank you very much. The pleasure is all mine.
Yeah, I also thank each one of the participants, but for your participation, this program would not have been possible. Thank you very much, and sorry that the question session could not be made. But however, all your queries will be taken and the answers will be collected and mailed to you. I think, Selva, we have mail IDs of all the members, no?
Yes, sir. We'll be sending the presentation along with the recordings,
Yes,
PDF file, and the recordings to all the members in 1 or 2 days' time. And also the questions will mail it to speaker and as at the SIR's leisure time.
Please collect and answer send the answers also to the respective question,
Yes,
the person,
and
the member who has raised the issue, or to all as you wish.
Yes, we
So
all
thank
we
you all
usually do
members
it
for
to
your
all participants, so we'll do that way, sir. Thank you.
Yes,
Thanks
yes.
for
Thank you very much. I thank the chairman also for fixing up this topic, and also the work of SIRC office and Mr. Selva for the technical support. Thank you very much.
Thank you.